Can you hear me?
Stephanie, can you please pause the live stream?
That's so strange. I just clicked. Yeah, it was. That's strange.
It's still showing live for us.
Yeah.
If you go to the 3 buttons for more,
Good morning, everyone. Before I officially call our case, let me just check in with our court reporter to make sure she is ready to go. Tracy, are you ready to go?
Good morning, Judge. I'm ready.
All right, thank you. Now calling proceeding number 22A-0563E. This is an evidentiary hearing on Public Service Company of Colorado's application for a certificate of public convenience and necessity for the conversion of the Pawnee generating station from coal operations to natural gas operations. This hearing was scheduled by decision number R23-0431-I. My name is Melody Mirbaba, and I am the administrative law judge who is assigned to hear this case. I want to let everybody know that we are webcasting this entire hearing. That includes video and audio. We will continue to webcast during any breaks that we take, so please keep that in mind. We also have a court reporter who is appearing remotely. So during the course of the hearing, I'm going to ask everybody to speak loudly and clearly and slowly. Another very important thing for those of you sitting at the tables is that in order to be heard, you've got to turn on those microphones in front of you. If you just tap where it says push, a green light will come on, and then you know that it's on. All right, so let's get started with entries of appearance. I want to start with public service.
Good morning, Your Honor. Franz Hardy and Greg Hearing of Gordon and Reese on behalf of Public Service Company. We also have Christopher Irby, in-house counsel for the company.
Thank you. For Natural Resources Defense Council and the Sierra Club, who I'm going to refer to as the Conservation Coalition or the Coalition.
Good morning, Your Honor. Matt Gerhardt appearing on behalf of the Conservation Coalition.
Good morning. On behalf of the Office of the Utility Consumer Advocate, who I will call the UCA.
Good morning, Your Honor. Michelle Singer-Nelson on behalf of the UCA, and with me is Kate Crampton, also on behalf of the UCA.
Thank you. For Climax Molybdenum Company, who I will call Climax. Okay, I'll note that nobody has entered an appearance for Climax Molybdenum Company.
Good morning, Your Honor. I hit the unmute button. My name is Richard Banyo, and I'm appearing on behalf of Climax Molybdenum Company.
All right, thank you. And for Colorado Public Utilities Commission trial staff, who I will call staff.
Yes, good morning, Your Honor. Michael Santisi and Christine Roach from the Attorney General's office on behalf of trial staff.
All right, great. I've got a list of preliminary matters that I need to review with everybody before we get started in the evidentiary portion of the hearing. One of my questions to start is whether we have any witnesses that are going to be testifying remotely. If anybody does have a witness who will be testifying remotely, just unmute yourself and let me know now. Okay, so
Your
it
Honor,
appears that, yes?
Sorry, this is Matt Gerhardt with the Conservation Coalition. My understanding is that the parties do not have any cross-examination for our witness, Alana Miller. And so I wanted to know whether Your Honor has any questions for her. She is available to answer questions remotely, but otherwise, if no one has questions for her, would ask that she be excused.
Yeah, I do see on the witness order and cross-examination matrix that was filed that nobody listed cross-examination for your witness. Since we're on this, I'll go ahead and just let everybody know what I'm anticipating in terms of who I might want to ask questions of. So to answer your question, Mr. Gerhardt, I do not have questions for your witness. So unless anybody else at this point wants to say they've changed their mind and they have questions, I will excuse your witness. I'll pause if anybody has anything to add to that. I also have, I do have questions for the company's witnesses. I'm not exactly certain who is going to be the best person to answer those, so all three witnesses should be available. I have some questions for the UCA's witness as well. And I may have a question for staff's witness. So I think that covers everybody that was listed. And I'll just say, all of that may change depending on what happens during cross-examination. So, all right, so other, yes.
Your Honor, Michael Santisi, trial staff attorney. You mentioned you may have a question for a staff witness. Would it be our witness that's in support of the settlement, or is it specifically for Ms. O'Neill?
I'm confident Ms. O'Neill can answer my question.
Okay, and I just wanted to say that staff's lead witness sponsoring the settlement is Mr. Gribb.
Okay, well, I'll put it to you this way. Whoever testifies first, I will ask the questions that I have, and if they can answer them, great. If not, you'll get to call the next witness.
Okay.
And at this point,
good,
I have maybe one question for staff's witness that could go away. And I also may get new questions as the testimony unfolds.
Okay, great.
All
Thank you.
All right, so we're going to take 2 breaks today. This should be about 15 minutes each. We'll go till about 10:30 and take a break. We'll have a recess at noon for lunch. I'm anticipating an hour. And then at 3, we'll take another 15-minute break. So I do, want to let everybody know that I have a lot of questions about the settlement agreement. And I'm going to ask the first witness who gets on the stand. I'm going to start with those questions will most likely be the company's witness. And I do expect that if any party to the agreement disagrees with any testimony that is provided that either clarifies or somehow modifies the agreement, I will expect the settling parties to speak up and let me know if you disagree. And you get to choose how you want to do that, whether it's through your own witnesses, whether it's through argument and your statement of position, whether it's through your own questions, that's up to you. But I will expect you to speak up if there is some clarification or modification of the settlement made through testimony. And I may even pause if it's a pretty clear change to get everybody to agree on the record. That's one of the primary areas that I'm going to be covering during my testimony. Or sorry, not my testimony, everybody's testimony. Okay, so I always ask if there are stipulations about the admission of exhibits, but before we get to that, I did want to point out that we've got a couple of confidential attachments to exhibits, that a public version of the attachment was not filed. And I have to have, if these exhibits are being offered, I have to have a public version. So those are Public Services Hearing Exhibit 104, attachments G, J, K, -3C, Rev 1. There is no public version of that. And then for the same exhibit, attachment G, J, K-4C, Rev 1. I don't have a public version of that. So if you want the confidential one in the record admitted, I need the public one, and you can get those ready and put them in your box. And I'll also just direct you to attachment B to decision number R23-0431-I, paragraphs 32 and 33 on what that should look like and what the requirements are for filing a public version of a confidential attachment. So now I want to turn to whether the parties have reached any agreements as to the admission of the exhibits that are listed on our hearing exhibit spreadsheet, which I think we've identified as hearing exhibit 800. I'll start with public service. Are there any stipulations as to the admission of exhibits?
Yes, Your Honor. From our understanding, the parties have stipulated to the admissibility of all of the exhibits. thank you for pointing out the confidential versions. What public service would like to do is to submit public versions of those two. So I think with the exception of those two that are currently confidential, the rest we would stipulate to their admissibility.
Okay. UCA?
Your Honor, we agreed that the parties have agreed before the hearing to stipulate to the admission of all the pre-filed exhibits and the attachments.
Okay. And I take that to mean the exhibits that are listed on hearing exhibit 800. Okay. Mr. Santisi?
Agreed, Your Honor.
All right, then. I'm going to admit, and I will go ahead and admit those confidential attachments since you have let me know you will be getting the public versions to me today. We can admit those later. There's obviously a lot of exhibits on this list, so I just want to take my notes and then I'll just run through them so we've got it in the record. All right, so by stipulation, we have admitted hearing exhibit 108, 101, 103, 105, 102 in attachments, 104 in attachments, 106, 107, hearing exhibit 301 in attachment, hearing exhibit 302, hearing exhibit 500 in attachments, hearing exhibit 700 in attachments, and hearing exhibit 701 in attachments. Now, are there any other exhibits that are not on hearing exhibit 800 that the parties have stipulated should be admitted into evidence? All right, I'll take that silence to mean no.
Your Honor, point of clarification. I don't know if you mentioned exhibit 100, which is the application.
That is interesting that you say that because I was about to bring that up.
Thank you.
Hearing exhibit 100 is not on the exhibit spreadsheet. So that was one of the things I wanted to mention. I think we've got some missing exhibits and some documents that I would like to have in the record. I think it will complete the record better. Hearing exhibit, I didn't know it was marked as hearing exhibit 100 because I'm not sure it has been filed as such, but it was not on the spreadsheet. Therefore, if we're going to get that into evidence, it has to be offered through the companiesbox.com folder. In addition, I noticed that a lot of areas of testimony in the application reference a commission decision, a couple of commission decisions. One is C22-0459 and proceeding number 21A-0141E and the updated settlement agreement in that case. In fact, it's that decision and that settlement agreement appears to be some precursor to why this application was filed. And there's a lot of references to it, but I did not find either of those documents in the record. And I'm just wondering if I've missed it. And if I have not, I would really like to see those two documents offered into the record. Box.com process can be used for that. Now, I know I can take administrative notice, but it is so much easier for the record to have it in our case. And then there was also, I think in testimony, references to proceeding number 22A-0515E and the decision number C23-0362 in that case. And possibly the settlement agreement in that case. But again, I'm not finding those actual documents in the record. And I would like to have them in the record. So I want to ask who could help me with that? Public service?
Yes, Your Honor.
Okay, thank you. And we can do that via the box.com process. All right, I think that covers my list of preliminary matters. Does anybody else have any preliminary matter that we ought to address before turning to the evidentiary portion of our hearing? Okay, I take that silence to mean none. And so let's get to the evidence. I am going to ask Public Service to call your first witness.
Your Honor, Public Service would call Michael Pascucci.
Good morning. Go ahead and turn that microphone on.
Good morning.
Good morning. All right, raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
Yes.
Okay, put your hand down, state and spell your name for us.
My name is Michael, Michael, Pascucci, Pascucci.
All right, thank you very much. And during the course of your testimony, try to do your best to speak into the microphone so our court reporter can hear you.
Will do. Thank you.
Thank you, Your Honor. Mr. Pascucci, will you, for the record, state by whom you're employed in your title?
I am employed by Public Service Company of Colorado as Director of Regulatory Policy and Analysis.
And you previously prepared and submitted direct, supplemental, direct, and rebuttal testimony in this proceeding?
Yes.
And did you review that testimony in preparation for today?
Yes.
And if I were to ask you the same questions in that prior testimony, would you give the same answers today?
I would.
And just for the record, Your Honor, those are here in exhibits 101, 103, and 105. Before we move further, Mr. Pascucci, based upon Your Honor's comments, are you familiar with the verified application in this matter?
Yes.
May I have just one moment, Your Honor?
Yes, you may.
Forgive me, Your Honor. Mr. Pascucci, let's move to the settlement agreement. What is the purpose of your testimony today?
The purpose of my testimony is to provide support for the approval of the settlement agreement. The comprehensive non-unanimous settlement agreement.
Can we please pull up hearing exhibit 108, please? Thank you. And Mr. Pascucci, is exhibit 108 the settlement agreement?
It is.
Were you involved in the negotiation and drafting of this agreement?
Yes.
And does it contain the electronic signatures of the representatives of the parties to it?
It does.
What's the purpose of the settlement agreement?
The settlement agreement represents a compromise by the settling parties to achieve essentially approval of this CPCN or recommended approval of the CPCN. Each of the parties made modifications to their stated positions through testimony in order to reach a comprehensive settlement that we believe works for all the parties and supports the public interest.
Who are the parties to the settlement?
The parties to the settlement agreement are Public Service, the trial staff of the Commission and Conservation Coalition. Climax Molybdenum took no position on the settlement agreement.
And the settlement, is it unanimous?
It is not unanimous. The utility consumer advocate did not support the settlement.
Without providing any confidential information, Mr. Pascucci, could you please provide some general background on how the settlement was reached?
Yeah, the parties met over several days prior to filing the settlement agreement to discuss various issues. Primarily, as evidenced in Section 2 of the settlement agreement, the parties spent significant time developing a set of performance incentive mechanisms to address the unique circumstances of this proceeding. We also resolved many of the issues reported related to reporting as well as timing of the conversion of the project.
And Mr. Pascucci, just to give us an overview summary, what's contained in the settlement agreement?
I'll possibly walk us through kind of section by section here. Section 1 requests approval of the CPCN, noting that the settling parties do not oppose the approval of a CPCN in this proceeding. Section 2 sets forth 3 different performance incentive mechanisms. The first is a cost management PIM. The second is a timing PIM. And the third is a unit performance PIM. This section also addresses how the company will either, I'll say, pay or receive any earned incentives through this proceeding and how they will be adjusted by achievement or failure to achieve certain incentive mechanisms. On page 5, section 3, we termed operational matters. This discusses how the company will operate the unit and essentially reserves the right of public service to operate the unit in the manner that it believes is the most safe, reliable, and cost-effective way, but reserves the parties' rights as well to challenge public service's operation of the unit in future proceedings. Section 4 addresses the timing of the conversion, again, reinforcing that the company, through the settlement agreement in the company's 2021 Electric Resource Plan and Clean Energy Plan, reached a settlement agreement that we would convert the unit to natural gas no later than January 1st, 2026, and that it affirms that public service has the opportunity to advance that in-service date if certain conditions can be met, such as ensuring reliability, resource adequacy, and cost effectiveness of the transition. Section 5 addresses reporting. There are 2 different reporting pieces here. First, the company commits to providing annual reporting in its annual Electric Resource Plan report filed on March 31st of each year. And we'll address general items in there like project management, project conversion, status updates, through that. In addition, in subsection B, the company commits to providing staff with certain reporting related to our project management plan. First, there are 4 pieces that we will provide to staff within 90 days of a decision in this proceeding. And then second, there is a safety plan update that we will provide no later than September 1st, 2024 to staff. We'll also file this into the record in this proceeding. Finally, section 6 is best value employment metrics. The company has not completed some of the contracting for this project, but upon completion of those contracts, the company will file information updating stakeholders on what our commitments are related to best value employment metrics, consistent with both the Commission's rules and the statute.
Mr. Pascucci, why don't we spend some time, thanks for providing us with that overview. Why don't we go through each one in some detail? And really with the objective of providing some detail, but also explaining how each is reasonable and in the public interest. So let's start with what you described as the performance incentive mechanisms. You mentioned or testified there are 3 aspects of it: the cost management, the timing, and the unit efficiency. Can you please describe for us the cost management aspect of the PIM and how it would work?
Yes, the cost management PIM is unique to this proceeding, given the circumstances that in phase 1 of the company's electric resource plan, the company put forward an initial budget of approximately $44 million. And then in the CPCN revised that budget after completing additional work, which resulted in an increase in the budget. So recognizing both stakeholder and commission interest in cost control, given that substantial increase, the company and the settling parties agreed to a performance incentive mechanism that has a baseline of $80 million, a 5% deadband around that baseline, and then a 10% share of any cost savings or cost overruns beyond that 5% deadband. The cost management PIM also includes a cap at $88 million.
And why is the cost management PIM reasonable and in the public interest?
The cost management PIM is reasonable and in the public interest because it does require the company to make best efforts to minimize its costs, or else it will incur penalties or could risk non-recovery of costs. By setting the baseline at $80 million, the company has adjusted what it would traditionally assume its baseline to be. It's requested budget approval in a CPCN to recognize that as costs have increased, the company will take on additional risk at that $80 million level. In addition, the cap that's set here at $88 million is about $1 million greater than our current cost estimate. But again, sets some, it increases the risk to the company that should the project not be completed under budget or on time, the company may incur additional risk in its cost recovery. So that really protects ratepayers against potential cost increases and puts the onus on the company to truly manage its costs and manage the construction of the project.
Let's move on to the second aspect of the PIM, Mr. Pascucci, the timing. Could you please describe how the timing PIM works?
Yes, there are two parts to the timing PIM. The first, and I think most important, is if the project is not completed by January 1st, 2026, the conversion of the unit is not completed before January 1st, 2026, the company will pay a penalty of $5,000 per day, or incur a penalty of $5,000 per day, beginning each day after January 1st. And second, that should the company be able to advance the conversion prior to the summer of 2025 or prior to January 1st of 2025, there is an incentive built in there. That incentive is designed to encourage the company to seek opportunities where possible to advance the conversion, consistent with the spirit of what we believe is the spirit of the settlement agreement in the electric resource plan, but also acknowledging that the company needs to consider reliability, resource adequacy, safety, and cost effectiveness in making that conversion timing decision.
Why is the timing PIM reasonable and in the public interest, Mr. Pascucci?
The timing PIM is reasonable and in the public interest because, one, it creates a penalty for public service if we do not adhere to the deadline to which we agreed to in the electric resource plan settlement agreement. And that presents the company with, again, further, it's not just a disincentive, but it is an incentive to avoid those additional penalties, to make sure that we construct the project on time, that we follow our timeline, and that we plan appropriately for this. It also provides an incentive to in-service the unit earlier, which could lead to potential emissions reductions, which would be in furtherance of the state's goals of clean energy and emission reduction goals.
Let's move on to the third aspect of the PIM, and that's the unit efficiency. Could you please describe for us how that aspect of the PIM works? And we're on page 4, section C. Thank you.
Yes, this section of the PIM, the unit efficiency PIM, effectively sets a baseline on how the company will, on the efficiency of the boiler following the conversion. The settlement agreement proposes one of two baselines can be used. The first is that we can use the baseline as defined in phase 1 of the electric resource plan, or the company, in conjunction with staff, can collaborate on developing an alternative baseline using the results of the company's boiler study. That effectively ensures that there is a baseline already set in the record in phase 1 of the ERP. There is modeling assumptions around the unit efficiency of Pawnee. However, the second part of that allows us to update that baseline to use more up-to-date information, I'll say, that reflects the actual operational characteristics of the new boiler that will be in service at the unit. The company, following the in-service of the project, presumably, let's say January 1st, 2026, We'll begin testing that heat rate or begin analyzing that heat rate in the first 3 years of operation. And should the company not achieve a result that is in 105% of that baseline, the company would need to forego any incentives earned in that year.
You said that there's two alternatives, Mr. Pascucci, on the formula. Why isn't that solidified in the settlement agreement?
It's not solidified at this time, as the settling parties just didn't have the time to develop the kind of updated baseline that we have contemplated here. Phase one is obviously in the record, but utilizes out of date and I'll say information that may not represent the best operating characteristics of the unit. And so given the lack of time that we had to fully develop a new baseline, the company and parties reached an agreement to develop that over time. Because we need to reach that decision before September 1st of 2025, it effectively ensures that should the project remain on its current schedule, we would have a new baseline proposed before the unit went into service.
And why is this provision of the PM reasonable and in the public interest?
This section is reasonable and in the public interest because, again, it provides another incentive for the company to manage the conversion of the project as well as manage the operation of the unit, consistent with some of the assumptions we've made in determining that converting the unit was a prudent decision. Here, if the company does not achieve the heat rates and the unit is not as efficient as we expect it to be, the company forgoes an incentive. But in addition, it provides information to the parties as to exactly how the unit is performing and if that performance is consistent with our expectation from the different studies we've completed on the project.
You've discussed or testified about the earning incentives or potential decreases. How would that work under the settlement agreement?
This proposal is slightly unique. Many of our performance incentive mechanisms treat things as a cash payment. For example, we have a demand side management incentive through those programs that's an annual cash payment depending on achievement of certain metrics. But in this case, what we have is an adjustment to our earnings on the project. And so should the company earn any incentive or incur any penalty, it would be amortized over a 10-year period. And then through the quarterly ECA filing would adjust the company's earnings based on its rate base from the Pawnee project.
And while we're working our way through the settlement agreement, you mentioned it as part of your overview. The settlement agreement also talks about operational matters on page 5, section 3. Could you describe that provision?
Yes, this provision was in place to address the company's concern that certain party recommendations and answer testimony may have constrained our ability to cost effectively, safely, and reliably operate our system. And the company is essentially requested through the settlement that parties include this language, which allows the company to operate its system as it believes it should be operated, but still retains the right of parties to comment on or oppose how the company operated. Typically, those types of questions are brought up through proceedings such as the ECA prudence review. And so this affords parties their rights to question how the company did, ask questions and seek disallowances, for example, but still affirms the company's responsibility to maintain its electric system.
And Mr. Pascucci, is this provision consistent with how public service generally carries out its operations?
In my understanding, yes, the company is generally responsible for the operation, safe, reliable operation of its system, and that we essentially own that burden, and parties provide comment or feedback on how the company does that through different proceedings.
So continuing on through the settlement agreement, let's move to the timing piece, which is section 4 on page 5. Can you please describe for us the timing component of the settlement agreement?
Yes, this section of the settlement agreement specifically addresses concerns raised by the Conservation Coalition in their answer testimony. To be clear, the company at no point in time intended to convey to the commission or to parties that we would not seek to advance if possible. So what this clarifies is that through the ERP settlement agreement, the company committed to in-servicing the project no later than January 1st, 2026, and the company reaffirms that deadline. But to the extent there are opportunities for the company to advance that schedule and do so cost effectively, safely, and reliably, the company will evaluate those opportunities and if possible, proceed with an early conversion. In addition, this language spells out the current expected timeline for the conversion as approximately 60 to 120 days. So assuming an in-service date of January 1st, 2026, that would put the start date of the conversion and the unit outage at approximately September 1st of 2025.
Why is the timing provision reasonable and in the public interest?
And this section is reasonable and in the public interest because, one, it does further provides an opportunity to further emissions reductions, which are a primary goal of the state of Colorado. But it also lays out opportunities for parties to maintain their rights regarding the company's operation and their ability to ask questions or oppose. It doesn't give public service, I'll say, blanket opportunity to do what it wants, how it wants to do it.
Let's continue on, Mr. Pascucci. The next section, section 5, addresses reporting. You gave us just an overview when you introduced this at the beginning, but can you provide some more detail about the settlement provisions on reporting?
Yes, because the project is not slated to begin for a couple more years, the company has committed to providing updates through its annual electric resource plan report. This report is filed March 31st of each year. And given that this conversion, the original genesis of it was through the company's 2021 electric resource plan and clean energy plan, it seemed administratively appropriate to update parties, especially parties to the settlement agreement, as to the status of the conversion project in a report that presumably many of them would be reading as it is. And so we will update on project accomplishments, timeline updates, and conversion status in those reports. The second item, this specifically addresses staff's questions around project management and concerns around the company's project management plan. Through the settlement agreement, we reached a reporting requirement where within 90 days of granting a CPCN, the company will provide a report addressing its permitting plan and timelines, a breakdown of the major tasks required to complete project, including the timeline for major task completion and expected completion dates, a procurement schedule for major equipment, and our annual budgets detailed by FERC account. Finally, by September 1st, 2024, the company is required to provide an updated safety plan report in this proceeding. That includes items such as fire protection and life safety drawings. So looking at really the safety plan around how the company will conduct the conversion. The, again, facility emergency communication plan and drawing, and code and standards drawings.
And why are these reporting terms reasonable and in the public interest?
To the first section of the report, the annual report, I believe that's reasonable and in the public interest because it will provide stakeholders with regular updates on the company's status as far as project management and actual conversion of the project goes. Again, because it is several years out or a few years out, it provides the company with an opportunity, presumably in 2024, again in 2025, and finally in 2026, to update parties as to, and the commission, I should say, as to where we are in the status, different steps we're taking to facilitate the conversion, and make parties generally aware of what is happening with respect to the project. Section B, I believe, is in the public interest because it essentially updates on some very important aspects the company takes seriously, such as safety, provides those to staff and to interested stakeholders so that they understand steps the company is taking to make sure that the conversion is safe, but also gives updates on timelines, updates on potential costs, so that parties have an awareness of how exactly the project is progressing in its early stages.
Just a couple more sections, Mr. Pascucci. Let's move on to the section on page 6 section 6 on best value employment metrics. Can you briefly describe that provision of the settlement agreement to us?
Yes, this language again, I think directly addresses a concern staff raised in their answer testimony, which was if the company was complying with best value employment reporting requirements. And I believe the answer to that is with the settlement agreement, yes, we would. Certain contracts, when we issue them, especially labor contracts, require that we evaluate best value employment metrics. As part of our solicitations, we will request that information from bidders. And then following execution of contracts, we will compile that information. And when we have finalized the final contract, within 45 days, file an update on all of those contracts and our compliance with best value employment metrics.
Why is this provision reasonable and in the public interest?
I would say it's reasonable in the public interest, first, because it is a regulatory requirement. It is in the commission's rules, and there are various statutes addressing best value employment metrics. So from a base starting position, it is a compliance requirement that the state has deemed important. In addition to that, it will also provide interested stakeholders and the commission an update on essentially the best value employment metrics assigned to or received out of the company's contracting process.
From moving on, we've got a series of general provisions, Mr. Pascucci, from page 7 to 9. Can you just briefly walk us through what these general provisions are in a broad sense?
Yes, my understanding is these are all essentially boilerplate provisions that go into all settlement agreements. For example, they don't bind any party to the settlement agreement to any future positions. They essentially agree that this was a negotiation undertaken in good faith, that each party kind of had give and take in this settlement agreement. And I think that's one of the important things for the parties to recognize, that the parties want to recognize in this, is the unique circumstances of this require that all parties give and take, and that there's no aspect of this that we felt could be modified without unraveling other sections of the settlement agreement as well. I believe those are probably the key provisions in there.
And are these provisions reasonable and in the public interest?
Yes, I believe they are. As I said, they are consistent with the general provisions that I've seen in other settlement agreements. And so I think they afford parties protection and allow them to retain their rights in future proceedings, but also essentially effectuate what we're agreeing to here.
Mr. Pascucci, as we conclude, you've walked us through the various sections of the settlement agreement, but more of a holistic question. Why does public service believe the settlement agreement as a whole is reasonable and in the public interest?
I believe that the settlement agreement in whole is in the public interest and reasonable because it allows for the conversion of the Pawnee unit, which no party opposes in this proceeding, and is part of our clean energy plan to reduce emissions as identified in our electric resource plan and clean energy plan. But with that, the settlement agreement includes PIMs, performance incentive mechanisms, and other requirements that put some burden on the company to comply with its cost estimates, to make best efforts to ensure that we are properly managing the project, we're managing it on time, on budget, that we are doing so safely, that we are considering holistic operations of our fleet when considering the conversion, and that we're providing adequate reporting to parties so that they feel informed and knowledgeable about what the company is doing.
Your Honor, may I have a moment?
Yes, you may.
No further questions, Your Honor. Thank you.
Okay, before you have a seat and we do cross-examination, I just want to say I noticed that the joint witness examination matrix does not indicate that public service reserved any estimated amount of time for any witnesses on direct examination. I'm assuming that was an oversight. Can you tell me how much time public service plans to spend on direct with your remaining two witnesses?
We have them available for questioning, Your Honor, but we weren't planning to call them as part of our direct case.
Okay. All right. So this was really the only witness you guys were directing.
That's right, Your Honor.
Okay.
And again, the other witnesses are available for questioning.
Okay, great. All right, go ahead. You can go ahead and step down. Thank you.
Your Honor.
And is the UCA ready to begin cross-examination? All right.
Good morning, Mr. Pescucci.
Good morning.
Yeah, just a moment here so I can see you.
Make sure you adjust that microphone and that it is on.
I think it's on. Can you hear
That's
me?
better.
Okay. And folks online can hear me as well. Mr. Pescucci, you mentioned, and I just want to clarify, you're testifying today as the company's lead witness. Is that right?
That's correct.
And as the lead witness, you are familiar and able to testify about your own testimony filed in this case.
I am.
And you're also able to testify about aspects raised in other company witnesses' testimony.
To some degree, I can answer some questions, but certainly there are issues that Mr. Bogner and Mr. Kelly both have more experience and knowledge on.
Okay, so to some degree.
To some degree.
And you're also familiar with testimony filed by interveners in this case.
Yes.
Okay. And in fact, you filed rebuttal testimony in this case, addressing the answer testimonies filed by those interveners.
Yes.
And in particular, answer testimony filed by staff in UCA.
Yes.
I want to talk to you about, I think this was sort of towards the end of your testimony just now. You testified about the reporting requirements created in the settlement agreement. And you testified that these reporting requirements will keep the parties and the commission informed about how the company's planning and progress is moving along. Is that right?
That's correct.
And ultimately, you want the commission to rely on the integrity of the company's planning in order to approve this settlement agreement.
Yes, I believe the company's put together a comprehensive plan and has agreed to update the commission and other parties on that plan as time goes on.
And that's part of the reporting requirement.
Yes.
Okay. And you're aware that some of the criticisms in answer testimony in this case centered on problems that interveners saw with the company's planning so far.
I'm unclear. Are you referring to parties' concerns about planning in this proceeding or more generally? Parties took, I think, different approaches to that question. So is there a specific, yes, I'm asking, is there a specific piece of testimony we're thinking about here?
Sure. And you had a chance to review Mr. Gribb's testimony.
I did,
right?
Yes.
Okay. And what Mr. Gribb noted in his testimony, one of the criticisms from staff was that from 2011 through 2018, the company's performance in relation to managing CPCN projects had a less than 12% chance that any single project would be completed on time and on budget. Is that right?
Could you refer me to the section of testimony of Mr. Gribb?
Sure.
Section.
If we could pull up hearing exhibit 700, please, and page 17. And if we could just scroll down to the bottom of page 17, please. I believe it's line 9.
Yes, I'm familiar with that section of his testimony.
Okay, and so what staff was articulating there was a concern that CPCN projects from their evaluation had not been completed on time and on budget.
That was staff's perspective. In my rebuttal testimony, I provided some discussion around this. Effectively, I believe what staff is comparing here is, I'll say to some degree, an apples and oranges comparison. It was a comparison of different types of CPCNs, including transmission construction projects, distribution construction projects, as well as generation construction projects. And so we're not necessarily comparing the same type of project conversion here. So while I understand Mr. Gribb, based on his calculation, reached that, I don't agree with his conclusion with respect to the Pawnee conversion.
Okay, and Mr. Gribb, in his testimony, you would agree, simply notes that this is their evaluation of CPCN projects.
Yes.
And in raising this concern in their answer testimony, staff noted, they talked about the Association for the Advancement of Cost Engineering, or ACE, professional guidance documents. Do you recall that part of staff's answer testimony?
I do, yes.
PSCO does not use the ACE professional standards for their planning estimates.
That's
that right?
correct.
Okay. And instead, PSCO uses its own checklist of items when developing a project estimate.
That's correct.
And that was also true that the company did not use the ACE standards, but instead used their own checklist when the company first developed the initial estimate of $44 million. Correct?
That's correct.
Now, with respect to that initial $44 million estimate, the company does not currently have and/or did not maintain the data necessary to perform a revenue requirement calculation for that $44 million capital cost estimate. Is that right?
That's correct.
By contrast, the company was able to provide, and I think that's one of the confidential exhibits we discussed earlier, the revenue requirement for its current estimate.
That's correct.
And in this way, the parties, the judge, the commission are unable to conduct a side-by-side comparison of the original $44 million estimate against the company's current revenue requirement estimate.
Well, that's correct. Yes, I don't believe any party in this proceeding has taken a position that the company's current cost estimate is incorrect or has been is missing any important details or anything like that. To my knowledge, no party has challenged our current cost estimate.
You were asked in the discovery process, the company was asked in the discovery process to provide the revenue requirement for the initial $44 million, correct?
I believe that's correct, yes.
Okay. And the company's response was that they did not have it.
That's correct.
Okay. In this vein of discussion about the company's planning, you would agree that there are not any work papers created by PSCO in the record to provide in support of this CPCN filing. And if it's helpful and would refresh your recollection, if we could pull up, this should be from box.com. It's hearing exhibit 503. This is staff's CPUC 1-3. Oh, no, it should be in the UCA box. It's my apologies. It's staff's discovery question, but in the UCA box. 503, please. And if we could scroll up just a little bit. And Mr. Pascucci, just, oh, I'm sorry, that's maybe too far scrolling. Thank you. Mr. Pascucci, just let me know when you've had a chance to review that.
Yes, I've had a chance to review that. Thank you.
Okay. And you were asked by staff through the discovery process about work papers including all formulae and supporting data to provide in support of this CPCN filing. Is that right?
That's correct.
And if I could,
Sorry.
and your response, you sponsored this discovery response, correct?
Yes,
And your response was that the company did not have any work papers to provide in support of this CPCN filing.
that's correct. In
And
Mr.
this,
Kelly's,
if I could, please. And this response was filed in August of 2023.
that's correct.
And you have not updated this response since then.
No, we have not provided an update.
And I think you were mentioning Mr. Kelly. Mr. Kelly provided, I think we talked about that confidential attachment of the updated revenue requirement.
I believe that's correct. Yes.
So kind of staying in this theme of the company's planning and the questions or the issues raised by staff in their answer testimony. It was your testimony a few moments ago that the reporting requirements of the settlement agreement are intended to address some of those concerns. Is that right?
That's correct. Yes.
Okay. And the reporting requirements are meant to establish some sort of way for the commission and other parties to verify the company's plans for certain aspects of this conversion.
I'd agree. Yes.
And it sets forth reporting requirements for annual ERP reporting.
That's correct.
And the settlement agreement also has some reporting due within 90 days of any grant of the CPCN. Is that right?
That's correct.
And the 90-day report was intended to address those concerns raised by staff and their reference to the ACE guidance documents. Is that right?
Yes, those sections are intended to address some of the questions around that. As we, I think, have explained, we don't use the ACE manual. So alignment is difficult to achieve perfectly with what staff's looking for. So through the settlement agreement, we were able to identify key areas that staff was concerned about and agree to reporting requirements around those.
Okay, and I think you've sort of alluded to the answer to this question, but the 90-day reporting requirement itself does not include the recommended 29-point checklist promulgated by ACE in their guidance documents.
It does not. The company doesn't track its project management planning in that same format. And so as part of the settlement agreement, the parties again identified key areas that staff was concerned about, talked about those areas within those 29 points, and then agreed to reporting on those areas.
Sure. And so the settlement agreement instead establishes reporting requirements for things like, quote, major task completion timelines and, quote, major equipment procurement, correct?
That's correct.
The settlement agreement does not actually define what constitutes a major task.
It does not, no.
And it does not define what constitutes a major equipment procurement.
It does not, no.
These plans that are part of the reporting requirement are only to be provided after this CPCN application is approved.
I don't think I totally agree that it would be provided after. The specific items listed in that section, subsection B, is begins 90 days after, but the company does have an electric resource plan report due March 31st of 2024. And I would expect the company will include some reporting on the Pawnee conversion in that report, which may or may not be prior to the issuance of a decision in this proceeding.
Okay, setting aside the already required ERP reporting, the 90-day reporting created by this settlement will occur after the grant of the CPCN.
Yes, that's correct.
You were asked questions on direct examination about the PIMs created by this settlement agreement and why you believed those PIMs were in the public interest for cost containment. Do you recall that line of questioning?
Yes, I do.
And cost containment was a big concern for the intervening parties in this case, correct?
I agree. It was a big concern for the parties and for the commission.
Okay, and for the commission. And the sort of specific concern raised is that the costs had essentially doubled or were approaching doubled from the original estimate.
That's correct.
And staff in their answer testimony linked their concerns about the cost associated with the current estimate. They linked that to their concerns about the company's lack of sufficient planning. Is that right?
Yes, that was staff's opinion.
And the parties, I think you alluded to this, the parties weren't the only ones concerned, the commission was also concerned.
Yes, I think the commission's decisions are very clear.
And one particular decision that made that very clear was a decision issued by the commission in this case when it set a procedural schedule and referred the case to the ALJ, correct?
Yes, that's correct.
And if we could pull up from UCA's box hearing exhibit 501. And specifically, if we could go to paragraph 14, please. I want to ask you a little bit about those cost concerns raised by the commission in this proceeding. And are we at, I'm sorry, I can't see, are we at paragraph 14 there?
Yes.
And in this decision, the commission articulated that they were concerned about the substantial increase in the estimate of costs, right?
They did, yes.
And they noted that they themselves had relied on the $44 million estimate when they approved this project in the 21A-0141E ERP proceeding. Is that right?
That's correct.
That they noted that they relied on that estimate when they provided the authorization for this limited scope CPCN application.
That's correct.
And if we could go down to paragraph 19, please. And the commission too linked their concerns about the cost increase to their need for sufficient planning information from the company. Is that right?
I'm sorry, could you repeat the question?
The commission articulated that they needed detailed and accurate planning information when making resource decisions because of this concern of increased costs.
Yes, they did.
And they noted in particular their need for accurate planning information from the company in order to avoid a quote bait and switch in cost estimates over time. Is that right?
Yes, the commission did note that in its decision. I would say no party in this proceeding states that the company conducted a bait and switch, and I would state the company in no way conducted a bait and switch in its cost estimation process.
Okay. And this is not a unanimous settlement agreement, correct?
That's correct.
And those words bait and switch, that's not something I said, that's something the commission said.
Yes.
Your Honor, objection, the commission's interim decision speaks for itself.
It's also not in the record. Counsel, I'm not sure. So first of all, I'm gonna overrule the objection for now. Counsel, it would be really helpful for the record to establish a little bit more of a foundation of what the decision number is that you're asking him about. I'm not sure I heard that. And the proceeding number and the date it was issued, and possibly it might be good to have it in evidence. Frankly, this is a decision from one of the proceeding numbers that I mentioned at the beginning of the hearing.
Thank you. Mr. Pascucci, the decision that we're discussing right now, are you familiar with that as decision C23-075-I?
Yes,
And that was a decision issued by the commission in this proceeding.
yes, that's correct.
Okay. And it was a decision issued by the commission prior to our hearing here today.
Yes, that's correct.
If I
Okay,
could have just a moment.
I think that clarifies it.
Thank you. Your Honor, I would move to admit hearing exhibit 503. I guess I apologize. I'm a little bit uncertain if that's duplicative since it is part of the record in this proceeding, but if not, I would move to admit hearing exhibit 503.
Well, aren't we on 501? 501, I think, is the decision.
Yes, I'm sorry, 501.
Okay. I will say I was initially confused because I thought this was a decision from one of the other proceeding numbers. I don't think we need it admitted into evidence because it's already in the record in this proceeding.
Okay.
Now you mentioned 503. Did you want to do anything with 503?
Yes, Your Honor, that was my reference to, those were the lines of questioning regarding discovery responses to staff. I would move to admit hearing exhibit 503.
Any objections?
No objection, Your Honor.
Hearing exhibit.
Okay, thank you. And Mr. Pascucci, we're talking about this concept raised by the commission about a concern about bait and switch. Do you recall that?
I do. Could I just ask, could we switch? Thank you.
And we talked earlier about your familiarity with staff's testimony. In Ms. O'Neill's testimony, she also highlighted the fact that the Pawnee conversion project was originally selected through the ERP modeling scenario against alternative ERP portfolios. Is that right?
Could you direct me to the section of Ms. O'Neill's testimony you're referring to?
Sure. Would that be helpful to refresh your recollection?
Yes, that would. Thank you.
If we could pull up hearing exhibit 701, please, page 11. And Mr. Pascucci, I'll direct you specifically to lines 17 through 20.
Thank you. Yes, I see Ms. O'Neill states that. And again, we'll note that even though it has doubled, no party, to my knowledge, in this proceeding has argued that the cost estimate is incorrect or unreasonable, or that there is an alternative, more cost-effective solution.
Okay, thank you for adding that. And what Ms. O'Neill had discussed was her concern that this $44 million original estimate had been relied upon and sort of selected as preferred against other options, correct?
That's correct. In the electric resource plan, there were a suite of different portfolios proposed, and the commission, and I should say the settlement agreement, essentially proposed this, and the commission adopted this, that kind of suite of assumptions.
Okay. And sticking on this concept and this concern of bait and switch raised by the commission, you're familiar with Mr. Gribb's testimony where he highlighted his belief that the company has little risk of this project being rejected because of the need to meet the state's decarbonization goals.
Could you refer me to that specific section?
Sure. If we could pull up hearing exhibit 700, please, page 9. And I'll direct your attention specifically to lines 6 through 9.
Thank you. Yes, I agree that staff's language there says that they believe there is a little risk of the commission rejecting the CPCN. However, I will note there's, I think, substantial risk that some of the company's cost estimates or performance incentive mechanisms may create penalties for the company for not achieving its cost estimates.
Okay. And kind of taking these together, Ms. O'Neill's concerns and Mr. Gribb's concerns and the commission's concerns, you'd agree that the cap created by the settlement agreement of 88 million is exactly double the original estimate of 44 million.
Yes, that's correct.
And that cap is not actually a hard cap, correct?
It is not a hard cap in that the company cannot recover costs above $88 million. It effectively puts the burden on the company to demonstrate that recovery is appropriate.
Right. The company can overcome essentially the soft cap if it can establish extraordinary circumstances.
Yes, if the company can demonstrate extraordinary circumstances, it would have the opportunity to cover some of those costs should the commission agree that extraordinary circumstances occurred.
And the settlement agreement itself does not actually define what constitutes extraordinary circumstances, correct?
That's correct.
That was not language that the settling parties agreed to include.
That's correct.
In that order that we were discussing, C23A-0363E, the commission also directed the parties to consider setting a baseline that would not result in rewarding the company for cost savings beginning from a point substantially higher than the presented cost estimates relied on by the commission. Is that right?
That's correct.
Here, the settling parties have agreed to a baseline of $80 million, right?
That's correct.
And you mentioned on direct examination, the dead band.
Correct.
And the cost savings become operative if the company's costs come in below that dead band.
Yes, the company could earn incentive if its costs came in below that dead band.
Meaning that if the company spent any amount less than $76 million, let's say, for example, $75.5 million, they would earn a cost savings earning increase, even though that amount is more than $30 million greater than the original estimate, correct?
The company could earn an incentive. It is also dependent upon the company achieving both the timing PIM and achieving the unit efficiency PIM. Those three PIMs should be viewed in conjunction with each other as they each have dependencies or impacts on the other.
If I could have a moment, Your Honor.
You may.
Mr. Pascuccio, I think you have the settlement agreement in front of you. So if I could just direct your attention to page 3.
Let's get that pulled up on the screen for those that are participating remotely.
Oh, thank you. Mr. Pascucci, the cost savings below 95% of the PIM baseline, the company would receive an earnings increase of 10% of those savings. Is that right?
That's correct.
Okay. And so 95% of that PIM baseline is $76 million.
That's correct. Yes.
Okay. And so anything under $76 million for total costs, the company could earn that incentive PIM.
Yes, that's correct. What I was saying earlier is that does assume, for example, the unit efficiency PIM, I believe, says that if the company does not achieve the unit efficiency PIM in one of those 3 years or any of those 3 years, we can't earn an incentive in that year. So to the extent that the company did earn an incentive on cost savings, but failed to achieve the heat rate, we would not be able to collect our incentive in that year. So again, just pointing out there are slight interconnectedness amongst these PIMs that determine whether or not you actually do collect the incentive.
And it's that unit efficiency PIM that the settlement agreement hasn't stated the baseline for.
I don't agree with that. It states that the baseline will either be the assumptions used in phase 1 or an updated assumption based on the boiler study modeling. So it doesn't state a specific number, no, but
Okay.
it does state the source of one number or the process by which another number will be developed.
Okay, so there's not a baseline number for the unit efficiency PIM at this time.
Yeah, I wouldn't agree with that. There's not a specific number stated in the settlement agreement, but there are numbers available in the electric resource plan that could potentially be utilized, or a number could be created.
Your testimony regarding that unit efficiency was that in part, the parties sort of ran out of time finishing developing that prior to the settlement deadline.
Yes, that's correct.
Okay. And you're familiar with Mr. Gribb's answer testimony, who noted the company had, in his judgment, 18 months to plan for this application.
Mr. Gribb did note that. I believe in our rebuttal testimony, we note that the company didn't believe it would be appropriate to begin conducting studies and begin conducting additional analyses prior to an approval of the updated settlement agreement, which didn't occur until the summer of 2022, about 6 to 9 months after the updated settlement was agreed to. And that some of those studies did take an additional 18 months following their beginning. So it has taken additional time to kind of gather that information.
And in talking about this concern raised by the commission in setting the baseline for a PIM in this proceeding, we talked about their concern about essentially creating a reward for amounts that are significantly above that original $44 million estimate, right?
Yes, I recall that language.
And on the other side of the PIM is that no penalty would be incurred for costs up to 5% greater than 80 million, which is costs up to $84 million. Is that right?
Yes, that's correct.
And under this scenario, the company could incur increased costs of $40 million over the original estimate before incurring a penalty, correct?
Yes, that's correct. Our initial assumption, as we discussed in my testimony, and I believe Mr. Kelly's testimony, was in part an incomplete assumption. And we did not communicate effectively as to how that initial estimate should be viewed and what it really consisted of. Now that we've completed studies and we've completed our analysis of what the conversion requires, we've put forward what we believe is the most accurate cost estimate we can.
And that initial estimate, that was the product of the company's planning.
That was the product of the company's project management plan, as well as several studies to determine what was necessary. Those studies conducted by third parties with experience doing this type of work.
Okay. And that was the information that Piesco was unable to provide to UCA in discovery.
I don't believe that's true. Could you refer me to where we said that in discovery? Apologies.
You recall the line of questioning earlier about that $44 million revenue requirement?
Well, the revenue requirement, yes, we were not able to provide information such as studies that the company completed. I believe were provided as part of the company's supplemental direct testimony.
I could have just a moment.
You may.
I don't have any further questions.
I have some questions, but I'm just going to need a second here really quick before I get started. All right, let's see what we can get done in the next 10 minutes before we take our mid-morning break. All right, let's pull up hearing exhibit 108, which is the settlement agreement. Let's go to page 2, paragraph Roman numeral 1. Okay, so this part of the settlement agreement says that the settling parties agree to recommend that the commission approve the company's application consistent with the changes required by the settlement agreement provisions below. And then, of course, the agreement goes on to identify numerous changes to the company's original application. I'll say that the way that I understand this provision is that the settling parties agree that any aspect of the company's application that is not modified by the agreement should be approved. Am I understanding this correctly?
Yes, I would agree.
Okay. I'm wondering how then this would address any changes to the company's application requests that were made through the company's rebuttal testimony.
If you mind, can I take a quick minute just to look at my rebuttal testimony?
Sure you can. It's just, there's obviously a lot. You weren't probably the only, let me just see if you're the only witness that submitted rebuttal.
No, we had 3 witnesses. Sorry, I guess were there specific items in our rebuttal testimony that?
I would just say generally, I think the rebuttal testimony modifies at least some positions, and I don't have like a long list of everything that the company changed after seeing answer testimony. But what I'm just trying to figure out generally is the agreement says we want the application approved unless or as modified by the agreement. Am I supposed to be looking at the original application then? Or am I supposed to be looking at that in combination with the implicit changes the company made in rebuttal testimony?
Thank you for the clarification. I would say we're looking at the original application, and then the settlement agreement is modifying that. The changes that we made in our rebuttal testimony, I would consider generally, or for example, the performance incentive mechanism. I had discussion of how we would modify our performance incentive mechanism in rebuttal testimony. Those would be superseded by what we agreed to in the settlement agreement.
Okay. And it's somewhat easy for me to figure out, what the settlement agreement does cover in terms of overall topics that are at issue. But what's harder to figure out is what it does not cover. Because this agreement term to me implies, and these are the things that we're changing from the original application, but then everything else that we're not changing should be approved. And so I think what I struggle with sometimes is figuring out, well, what's left that's not in the agreement that the parties have agreed should be approved. And I will let you all know, preview, I'm going to ask for this in statements of position. Okay, as I'm understanding your testimony, I should be looking at the original application and the company's position on the original application.
Yes, I think that's fair.
Okay. So in your direct testimony, and we can pull it up if you need it, but why don't I just ask the question first and you can let me know. You described this proceeding as a limited scope certificate of public convenience and necessity, which we all call a CPCN. Hoping you can elaborate on that for me.
Yes, the limited nature of this refers back to the company's electric resource plan and clean energy plan, where the commission had already decided or approved the updated settlement agreement, which said that the company would convert the Pawnee unit. So the CPCN was more limited in scope to outline specifically the costs and the proposed timing of the conversion. So that's why we've provided the updated $87 million budget estimate, and we've provided the timing that we expect to be to complete this in the fall of 2025.
And in terms of its limited scope, then, is there, as I understand it, that the company is, according to a commission decision that is not in the record, that the company is not required to present an analysis of alternatives to the Pawnee conversion. Is that right?
That's correct. The settlement agreement, apologies again, that settlement agreement in the electric resource plan does state that essentially we would not conduct additional analyses, in part, I believe, because those were discussed at length in the electric resource plan, and we identified several different options and eventually reach that kind of settlement conclusion.
Okay. And for the record, when you were referring to the ERP proceeding, you're referring to proceeding number 21A-0141E, correct?
That's correct, Your Honor.
And the commission's decision on the updated settlement agreement in that case.
Yes, that's correct, Your Honor.
All right, let's get back to the settlement agreement, hearing exhibit 108, page 2. I'd like to scroll down so that we can see all of Roman numeral 2A. Let's see. There we go. All right, so this agreement term says that the settling parties agree that the baseline for the PIM will be set at 80 million with a cap of 88 million, subject to the company bearing the burden to establish that extraordinary circumstances warrant recovery of any costs, and then goes on to refer to AFUDC, any costs that are above that 88 million. So I want to make sure I understand this agreement term. I think that UCA's counsel called this sort of a soft cap, and that's really how I see this $88 million. So we'll just call it, for argument's sake, a soft cap. So I read this language to essentially identify the range of 80 to 88 million as a presumed cost for the conversion. Is that a fair reading?
I would say the presumed cost for the purposes of a cap, yes. The reason I hedge a little bit is in the company's testimony, we've provided a cost estimate that, as we noted, is approximately $76 million to construct it, plus $4 million of AFUDC costs, plus $7 million of additional risk reserve. So there is some assumption built in there that should everything go perfectly right, the cost is $80 million, where we set the baseline. But recognizing that there are risks, I guess we'll say they're calculated risks that we don't bake into the overall cost of the project, but can not unreasonably expect to come to fruition. So I think your treatment of the 80 to 88 million is a range in which we think it's possible for it to come in, but I don't want to say that. I don't want that to imply that $80 million is the minimum the company would end up spending on the project.
So it could be less than 80 million.
Potentially, if everything went well, it could, and the company found additional cost savings, it could be less than 80 million.
Okay. So as I mentioned, I'm reading the reference to the 88 million as creating something like a soft cap, which essentially requires the company to prove extraordinary circumstances justify cost recovery above that $88 million. Is that a fair reading?
Yes, that's correct.
So just to play this out, I want to give you a hypothetical. So assume that the company's cost estimates just ultimately end up being just off, and the company ends up spending 90 million on the conversion, and that additional 2 million above the soft cap amount was prudently incurred. Do you agree that this agreement term would require essentially that unless the company can prove that recovery of that additional $2 million in costs is warranted based on extraordinary circumstances, that the company would be denied recovery of that $2 million in prudently incurred costs?
I would agree that yes, the company would have the burden of proving that incremental spend was both prudent and was the result of extraordinary circumstances, yes.
But if the company doesn't prove extraordinary circumstances and the costs are prudent, the company would forego recovering that $2 million.
I think it would depend on the circumstances of the time. The company may still seek recovery of those. But again, I think the company would have a burden to prove that those costs were both prudent and should be eligible for recovery.
Right. Well, my question is, assume that the commission finds that the company doesn't prove extraordinary circumstances. Under this agreement language, the company would forego recovering $2 million in prudently incurred costs.
I think, sorry, I'm not trying to hedge here. What I'm trying to think through is what the circumstances could be, in part because I don't expect our cost estimates to be off. I don't expect that we're going to spend more than that. I understand these costs have increased, but I provided some information in my rebuttal testimony that the company does a very good job on its generation projects in maintaining cost discipline. So when you say a situation where there is not extraordinary circumstances, it's certainly possible, and I think the company would be at risk not to recover those. But I don't want to rule out completely that the company would be totally unable to seek and the commission approve those costs if they were prudent.
Well, according to this agreement language, if you can't prove extraordinary circumstances, then what are your other options for recovering that $2 million?
And I don't think there really are a lot of other options. I think the company, essentially what I'm saying is I think the company has an opportunity to ask for it, but that doesn't mean that the company just gets to recover it. The commission could certainly deny, and I would expect would deny the company's request for that, but we would still have the opportunity to ask for that.
Okay. So on cross-examination, UCA's attorney highlighted the fact that the agreement does not define what extraordinary circumstances mean in the agreement. What is company's position on type of extraordinary circumstances that would need to be shown to warrant recovery of any costs above that $88 million?
Your Honor, I could give you a couple of examples of things that I know I have thought about. I don't want to limit the potential for extraordinary circumstances to just those, but one that obviously sticks out, I'm sure, in many people's mind is the pandemic, the COVID-19 pandemic, with both supply chains breaking down, people not being able to work in the office, with work being delayed due to sickness and trying to slow the spread of the pandemic. That would be one example, I think, of extraordinary circumstances. That's not something that we plan for routinely, and I don't think the commission would want us planning for a pandemic to occur on every single project. Another idea would be same thing, or be similar in that a breakdown in supply chains. I know one thing people have said internally is, a war occurs somewhere, or a manufacturing plant goes out of business after we submit our order, and now it will take an additional 18 months to reorder that part we need. Those would be extraordinary circumstances, again, things that we don't necessarily plan are going to happen, and I don't think we'd want to plan a redundancy to purchase two of the same piece of equipment in case one goes bankrupt or shuts down. But those would be the type of, I think, two simple examples of an extraordinary circumstance.
Okay, so the types of examples I think you've given me would be national emergencies like a pandemic and the potential cascading impact that they could have. Possibly, I don't know if you gave this as an example, like an act of nature that could have created circumstances outside the company's control affecting the costs. Is that a fair?
Yes, Your Honor. An act of nature, a tornado or a wildfire occurs at the plant. I think would be another extraordinary circumstance the company doesn't plan to have occur at its facilities or during the project.
So with extraordinary circumstances, are we really looking at things that happen outside of the company's control with that the company could not foresee and plan for, or cannot reasonably or prudently foresee and plan for?
Yes, I think that's fair. It would be things that the company cannot reasonably foresee and plan for, is what we're looking at here.
All right, now I want you to go ahead and look back on the either paper in front of you or on the screen. And we're still looking at hearing exhibit 108. And just read room numeral 2A1 and then go to the next page and read 2A2 and 3. And the reason I'm asking you to do that is that I have a question that involves reading all of this together and making sense of it together. Just let me know when you're done.
Yes, I've read those sections.
All right, I'm just going to ask this and then we'll take our break. I apologize. And just realized a little bit of time passed there. Okay, so when I'm reading those 3 paragraphs together, paragraph Roman numeral 2A1 through 3, I read them in conjunction to mean that the company could recover costs above 88 million if it meets the extraordinary circumstances standard, or burden, I guess, but that the agreement does not allow the company to receive a return on costs that exceed that 88 million. Am I understanding this correctly?
I would say to kind of holistically explain, if you don't mind, Your Honor.
Yes.
The PIM would set a baseline of 88 million. There's a 5% dead band around that. So between 95 and 105%, if the company actual costs fall within that, there's no penalty or incentive incurred, no adjustment to future earnings in any way. Should the company fall between 105% and essentially 110%, the 88 million, 10% of those costs, so maximum it seems would be about $400,000, would be amortized over a period of 10 years and would result in a decrease in the company's earnings on the Pawnee plant. But up to that 88 million, the company would recover its earnings on that. I realize I threw the amortization piece in there, which is discussed a little bit later, discussed in subsection D, section 2, subsection D. So clarifying how it work up to 88 million. At the 88 million, if the company exceeded that amount and we were denied recovery of those costs for whatever reason, the company would not earn a return on that amount over 88 million.
Okay, but let's say you are not denied recovery of those costs, that the company proves extraordinary circumstances, then is the agreement intended to give the company earnings, an incentive, a PIM, on costs above that 88 million?
Yes, I believe the company would be able to earn its return on those costs above the 88 million if we were to prove extraordinary circumstances and receive recovery of those costs.
Okay, so I'll just say this is something that confused me a little bit because the agreement repeatedly refers to up to this cap of 88 million. So it sounds like a PIM can be earned above the cap of 88 million, but only if the company proves those amounts above 88 million, recovery is warranted by extraordinary circumstances. Is that right?
Yes, that's correct.
Okay. All right, I want to talk about, let's go to page 4. Oh, actually, I almost got excited there and forgot we need to take our mid-morning break. Okay, it is it's almost 10:40. We will take a 15-minute recess and be back at 10:55. Again, I'll remind everybody that the webcast will continue, and if your microphones are on, you will be picked up and webcast online. All right, we will be in recess. Tracy, are you there? You ready?
I'm here and I'm ready.
All right, we'll go back on the record. Apologize about that. All right, so let's get hearing exhibit 108 back up. Go to page 4. All right, I want to talk about paragraph 2C, which is there at the top of page 4. So here's where the settlement agreement indicates that the company will set the baseline for this PIM, which is a unit efficiency PIM, based on either the phase 1 modeling or the Pawnee boiler study, and that the company will provide this calculation to staff and confer on the methodology used to develop the baseline. So I'm wondering, does the company anticipate that the baseline for this PIM will be the expected heat rate of Pawnee after the conversion?
Yes, Your Honor. The language here is essentially phase 1 used an assumption prior to the boiler study being completed. And so now that the boiler study is complete, what we're effectively saying is it's an opportunity for the company and staff to confer on an updated heat rate assumption that more accurately reflects the design of the actual boiler that will be installed. And then that will be used as the baseline to measure actual performance once in service.
Okay. Will there be an opportunity for staff or any other party to challenge the baseline that the company calculates?
Yes, staff would definitely be able to challenge, ask questions. We would expect to do is sit down internally using the information from the boiler study and develop what the baseline would be based on that information, provide that information then to staff to review, provide feedback on. I expect we'll have to have conversations about that to understand. And then assuming we reach an agreement, I would expect us to file in one of the annual reports what that new baseline is.
What if you can't reach an agreement with staff? What are staff's options under the settlement agreement?
If we could not reach an agreement, the option would be to default back to the phase 1 assumption. So the language in that section that says it's phase 1 or effectively provides I'll call it a safety blanket, that if we cannot reach an agreement, there is an approved baseline. It is the information used in the phase 1 assumptions. And I apologize, when I say phase 1, I'm referring to phase 1 of our electric resource plan, where the commission first approved the conversion of the Pawnee plant as part of our clean energy plan.
And that would be, again, proceeding number 21A-0141E.
That's correct, Your Honor.
Okay, then if I understand this correctly, staff, the agreement does not give staff the opportunity to raise any objections to the commission later down the line as to the baseline.
I don't know that staff would need to raise objections to the baseline because
That's not my question.
yeah, I apologize. What I'm thinking of here is I don't see a situation where the company would put forward a baseline that either was not phase 1 or that the company did not agree to with staff. If staff does not agree and we cannot come to an agreement on the updated baseline, we would not utilize that baseline. The language is there that it is not, the company does not have the unilateral decision to update the baseline. If we cannot come to an agreement on what an updated baseline is, we cannot use the updated baseline. So that's why I apologize. I know I wasn't directly answering your question, but wanted to make clear that this is not a company decision to make as to what the baseline is. It's either phase 1 or an agreement between staff and the company. And if we have that agreement, we will update it. But to the extent the company can't reach that agreement, we will not update it.
Okay, so it sounds like the answer to my question was yes, that the staff, there's another option built in, which is to default back to the phase one ERP assumption, but that staff does not have the opportunity to raise this issue with the commission at a later date under this agreement.
Yes, that's fair. Yes.
Okay. Okay, so in this, I'm still referring to the same settlement agreement term on page 4 of hearing exhibit 104. It says here, testing will begin the first calendar year following in-servicing and continue for 2 additional years thereafter. What is the frequency of the testing that the agreement anticipates?
The frequency is 3 years.
How often every year?
So the heat rate is an annual heat rate. I will direct you as well to Mr. Kelly for real specifics on how you calculate and measure a heat rate. But essentially the company would measure the heat rate on an annual basis based on the methodology we determine, and then would report on it in, let's say, assuming in servicing on January 1st, 2026, we would report on it in 2027, 2028, and 2029.
Okay, thank you. And you mentioned 3 years because it begins the first calendar year and then continues for 2 additional years thereafter.
That's correct. And the first calendar year was essentially to ensure that if we in-serviced it, let's say we did in-service it early on May 31st of 2025, it allows us to run the unit for a full year and calculate it based on a full year of operations before we start determining did the company achieve it. My understanding, again, Mr. Kelly can certainly walk you through the intricate nuances of this if you'd like, is that a heat rate calculation is dependent on certain factors, certain temperature and other weather conditions. And so without the ability to run it during the whole year and average or look at the entire year, there's a potential that you could skew the results based on lack of available information.
When I think of a calendar year, I think of a calendar, January to December. And the calendar year is what's referenced in the agreement. What you've described to me doesn't sound like a calendar year. So I want to make sure I've understood what you said correctly. That testing, the agreement is intended to allow for testing to begin first after the plant has been in service for a consecutive 12 months from the date of service. Is that right?
We were looking at it, the company was looking at it from the perspective that, again, let's say it was in service May 31st, 2025, that we would calculate the annual heat rate based on January 1st, 2026 through December 31st, 2026. And so we would base it on that full year of implementation, not 12 years, not 12 months from the date of in-servicing.
So then there's no testing from that May to December period.
Correct. Again, just
Okay.
acknowledging there some lost time in there. And if you're doing an annual calculation, you lose some of that.
All right, that makes this reference to calendar year make a lot more sense. Thank you for clarifying that for me.
You're welcome.
All right, let's go to page 5 of hearing exhibit 108. I want to talk about paragraph 4, Roman numeral 4. And you talked a little bit about this on direct examination. This is the paragraph of the agreement that talks about timing of the conversion. And I'll just say, I understand this to essentially give the company some flexibility so that, and just in terms overall of the conversion's timing, to complete it earlier than the January 1st, 2026 deadline. Am I understanding that correctly?
You are.
Okay. So on that note, I want to ask you about a concern that one of the UCA's witness raised about timing. And we can pull up the testimony, but just why don't I ask the question first and you can let me know if you want to look at the testimony. And I'll just for the record say this is in hearing exhibit 500, page 14, lines 8 to 9, where Mr. Neal states that early conversion, essentially before 2026, will likely result in even higher costs and greater emissions than expected. I'm wondering how the company responds to this.
I think that is something the company would need to consider in advancing that. And that's why I think we note in my testimony and others that it is a cost effectiveness question as well. We would not want to advance the timing of this to simply in a way that risked reliability or that resulted in increased costs to customers. I think our general belief is that if it's possible to do, we'd want to do it in a way that ensured we could achieve our emissions goals. Our electric resource plan and clean energy plan and state statute require an 80% emissions reduction by 2030. And we expect that we'll have an emissions performance incentive mechanism in the ERP. So in order to achieve that target and to achieve whatever that PIM winds up being in that proceeding, we would need to consider what are the incremental emissions associated with that. So it is not a simple answer, but it is something that we would obviously need to consider in doing that.
Okay, so I want to ask you another question about something else that Mr. Neal with the UCA testified to. And again, if you need to look at the testimony, just let me know. I'll just let everybody else know. I'm referring to his testimony in hearing exhibit 500, page 14, lines 19 to 20, where Mr. Neal suggests that that Pawnee's conversion be timed for when replacement resources are operational. I'm wondering what the company's response is to this.
So with any project that we conduct, the company, and I think Mr. Bogner can speak to some of the specifics of this as well. The company does look at what resources it has available, what resources are already planned for outages, what resources are unavailable due to a forced outage, what our capacity position looks like at the time and our forecasts look at the time. So understanding that Mr. Neal is concerned about resource adequacy here, which is an appropriate concern to have for all of us, I would say two things. One, the company would be evaluating that. The unit is already scheduled for a maintenance outage during that fall. Fall and spring are times when usually demand is a little bit lower, and we can schedule those with a little bit more flexibility. Alternatives being, summer is usually hot and there's higher demand. So we're already considering some of that and trying to align this under the current schedule with the outage that we're already planning to do. And effectively, the other, I think, thing I would note is that some of the resources that were bid into the electric resource plan, that while they show in the table Mr. Neal referenced a 2026 is when they first appear, that is the first summer. That table is reflecting the first summer of those capacity resources. Some of them were bid with in-service dates prior to the summer of 2026. So there's an awkward timing in how that was presented versus how that table reads versus how a bid is actually developed. So I don't believe that there is a major concern right now with, do we have the resources to do it? The company's already planning for that. We've already looked at that.
Okay, so it sort of sounds like, based on your response, that you've understood the UCA's testimony that Pawnee's conversion should be timed for when replacement resources are operational as being a reference to the period of time during the conversion that Pawnee will be out of service. Is that how you've been understanding?
Yes, that's how I understood it, was that if you're going to take the unit offline, you'll need to replace it with other resources. And the UCA was concerned we did not have resources, specifically clean energy resources, to replace it.
So the Conservation Coalition responded to the UCA's testimony on these issues. And we can pull it up if we need to, but for the record, I'm referring to hearing exhibit 302 Rev 1, page 5, lines 19 to 22, where the Conservation Coalition witness says that the UCA conflates conversion with retirement of the plant by implying that Pawnee's current capacity would not be available after the plant is converted, thereby resulting in capacity shortfalls until new renewables are built in 2026 or the new gas projects are in service in 2027. Just wondering what well, the company agrees with this testimony.
Yes, we would agree. And that was the point I was trying to make a minute ago with you is the company plans, when we take a unit offline for a conversion such as this, the company plans that conversion and that timeline around the availability of other resources as well as expectations around our system. Once that conversion is complete, the unit is back online. So we're not trying to permanently replace that unit. And in that, we're not permanently replacing that unit as you would under a retirement. There is a period of, 3 months, 4 months where the unit will be out of service for the conversion and for the outage, and then it will return to service. So it's during that window that we need to have replacement generation. And we look at that and determine, do we have sufficient capacity and our system conditions appropriate enough that we can take that unit offline without risking reliability and resource adequacy.
Right. And then when the conversion is done, essentially the conversion replaces the original coal-fired generation resource. Is that right?
Yes, that's correct.
And you might have already covered this in your prior answers, but I'll just give you the opportunity to add anything more. And that is, how does the company plan to ensure that the Pawnee conversion does not negatively impact service reliability and costs to customers?
Yeah, that's a lot of what we've been talking about the last couple of minutes, Your Honor, is just we will look at all that. We'll look at, do we have the resources? Did something come offline sooner or at an unexpected rate? And need to determine prior to that, can we still do it? Is there an unforeseen and extraordinary circumstance that we need to consider here? And that's part of the value of the flexibility in being able to do it earlier, is if there is something that today is unforeseen, but in the future becomes more clear. If there's an opportunity to do that, we have all the parts in place, contractors on site, and system conditions in the spring warrant it. We may be able to advance it in order to avoid a conflict, let's say, in the fall. But as of right now, given that the outage is already scheduled for the fall, that's an ideal time. We've already planned for that unit to be out and planned to make sure other resources are available to cover its capacity.
And when you say the outage will be in the fall, I think you testified earlier, we're talking about September of 2025. Is that right?
That's correct. That's the current timeline.
Okay. And under the settlement agreement, the same paragraph we were just referring to, which is hearing exhibit 108, it says that if the unit is currently expected to be out of service between 60 and 120 days. So it's 60 and 120 days starting September, I assume, 1st, 2025. Is that right?
That's correct.
Okay. So if you go to the 120 days end on that, then we'll get into 2026, won't we?
Yeah, I think that would take us to effectively January 1st, 2026.
Okay. All right, let's pull up hearing exhibit 105 and go to page 25. All right, now go ahead and review lines 1 through 16 and let me know when you're done.
Yes, I've read that.
Okay. So in this part of your rebuttal testimony, you're responding to the UCA's answer testimony that there should be no flexibility as to the timing of the conversion and that the company should be required to prove that there is sufficient generation capacity before moving forward with the conversion. And I think that this is most likely in reference to hearing exhibit 500 on page 11 and 12. You say that the UCA's position contradicts the settlement agreement, and that's on lines 10 to 12.
Yes.
So first of all, are you referring to the settlement agreement in proceeding number 21A-0141E?
Yes, I'm referring to that settlement agreement.
Okay. Is the UCA party to that agreement?
Yes, the UCA was a party to that agreement.
How does the UCA's position contradict the settlement agreement in that case?
The settlement agreement required the company to convert the unit by January 1st, 2026. And our position is that it is the company's responsibility to uphold the settlement agreement, and we must convert the unit by that time. The commission approved that language. And so the reassessment and reconsideration of whether the company should do that, I believe is in contravention to what the settling parties agreed to and the commission approved, which is we will convert it by that date. What we're essentially asking for now is to reconsider at some time in the future, should we uphold the settlement agreement based on new facts on the ground? I think it's our responsibility to comply with the settlement and make sure we do so in a cost-effective, reliable, and safe manner.
All right, I want to give you a hypothetical. And this hypothetical relates to the capacity questions that have been raised. So let's assume, and suspend your disbelief for me here, okay? Let's assume that Pawnee is successfully converted to gas in time for the summer of 2025. Let's also assume that no additional renewable resources from the ERP and CEP phase 2 are online by the summer of 2025. Under this hypothetical, how will Pawnee's conversion impact the company's operations?
So the conversion by that date, again, by the, I'll say May 31st, 2025, prior to the start of the summer season, would effectively have first an impact of completing the conversion. So now we would not need to conduct a conversion in the fall. It would provide additional potential capacity in the fall or allow us to adjust other schedules. Second, I think one of the main benefits of that is it could reduce emissions. The coal plant is expected, the gas plant following conversion is expected to have lower emissions than the coal plant. So that would allow us to reduce emissions in line with state goals and our projections in the ERP.
Well, my question was really about how would having that conversion completed in the summer of 2025 affect the company's operations? And really what I'm talking about is decision-making in terms of, generation resources and renewable resources.
That is probably a great question for Mr. Bogner. If I understand correctly, you're asking if the unit is converted and it's available that summer, how would you run that unit? Would you run it differently, or would it result in different operations for other resources?
Possibly. Let me ask a different question and see, and then you can tell me if Mr. Bogner would be better. In this hypothetical, would the company anticipate that it would be able to integrate more renewable resources during the summer of 2025 than it would have otherwise if Pawnee remained coal-fired?
Yes, I will ask you to ask Mr. Bogner that
Okay.
question. He is the expert there.
All right. So do you agree that the company has a financial incentive to complete the conversion as quickly as possible, given that the converted Pawnee plant will add approximately $80 million into rates?
I believe the company has an incentive to complete it as early as possible for multiple reasons, not just to put it into rates. Putting it into rates does potentially reduce costs. It could reduce our AFUDC expense. It could have potential emissions benefits to converting it early. And so there are certainly incentives to doing so, and that's part of the reason the incentives for the timing are set at the level they are. We did not, in the settlement agreement, want to provide an incentive to the company to convert and not consider anything else. It does come back to, for us, the reliability of the system and making sure that that incentive was set at a level that it didn't incentivize us to say reliability doesn't matter, let's get the money, but also that hey, if you can do it, if everything falls into place and there's an opportunity, here's an additional bonus to reward the company for some of the benefits that are achieved in that early conversion.
So you might want to direct me to somebody else on this one, but you can go ahead and let me know. I just want to learn more about the anticipated flexibility of the converted plant once it's converted. So once converted, how much time would you anticipate that it would take Pawnee to reach minimum and maximum load?
Those are great questions for probably Mr. Kelly and Mr. Bogner.
My next question, you might say the same thing, but I'll go ahead and ask it. For comparison purposes, what is the approximate time for the coal-fired Pawnee to currently reach minimum and maximum load?
Again, yeah,
Okay.
Good questions for them.
After the conversion, will Pawnee have a dual fuel capability?
Yes, the unit, and Mr. Kelly can talk more about the specifics of it, but the unit is expected to have some ability to utilize hydrogen in the future. And in the electric resource plan, that preceding number 21A-0141E, we did assume that beginning in 2041, it could burn hydrogen.
So no fuel, oil, or diesel?
No, the assumptions were, I believe, gas and hydrogen.
Okay, thanks. Does the company anticipate having a firm gas contract related to Pawnee?
I believe the answer to that is yes, but I would ask Mr. Bogner to confirm for sure for me.
All right, that might be all of my questions for you. Just give me one moment to review my notes. All right, that's all I have. Any redirect?
Before we begin in earnest, point of
I don't believe that microphone is on, sir.
oh, thank you. Is this better?
Perfect, thank you.
Thank you. Mr. Pascucci, just a point of housekeeping. If we could refer to public services box, and there should be an exhibit in there 100, please. Thank you. Mr. Pascucci, could you identify that document, please?
Yes, this is the verified application of public service of Company of Colorado for approval of a certificate of public convenience and necessity for the conversion of Pawnee Generating Station from coal operations to natural gas operations.
Are you familiar with the application?
Yes.
Your Honor, we'd move for admission of hearing exhibit 100.
Any objections? There being no objection, hearing exhibit 100 is admitted into evidence.
Thank you, Your Honor. We can pull the exhibit down. Thank you. Just some points of clarification, Mr. Pascucci. Your Honor asked you a series of questions about hypotheticals on the extraordinary circumstances, and more specifically as to the earnings on the $88 million. Is there something that you wanted to clarify on that issue?
Yes, I can clarify that issue. Specifically, what what I was intending to say in that is that to the extent the company exceeds the $88 million because of extraordinary circumstances, and the commission approves the finding of extraordinary circumstances and that those costs were prudent, the company would be able to recover those costs and could earn its return on those costs. However, should the company simply misestimate or there are not ordinary or extraordinary circumstances, the company would not have the ability to recover costs above the $88 million.
You were asked by UCA's counsel about discovery response on work papers. I think there might have been a little confusion on what that was referencing as applied to the $44 million initial estimate. Are you familiar with any work papers associated with that initial $44 million estimate?
No, it is correct that for that initial $44 million estimate, there were not work papers. What the company had done as part of its phase 1 electric resource plan is provide a high level assumption, kind of an initial estimate of what it would cost to physically convert the plant. It was not a CPCN quality estimate. We poorly communicated the intent there, I believe, and we probably should have in retrospect, we should have more clearly articulated what the intention of that cost estimate was. But it was a high level estimate and there were not work papers or detailed revenue requirements for that $44 million.
So let's pivot to the current estimate, Mr. Pascucci. Certainly there's been some focus on the increase, and you were asked questions about the original amount to this amount. What gives the company confidence that the current cost estimate is accurate?
So this current cost estimate is based upon several studies and additional project scoping and analysis following the company's project management process. And so it's a much more informed estimate. And that's why it's the estimate that we're bringing forward in what I would call a CPCN quality estimate. We're asking for in this CPCN approval of the cost estimate now that we have the full information to identify the unique circumstances for the conversion of the unit. And so that's why we've essentially done the full due diligence that would be expected on a project, and I would expect the commission would expect us to do for a project of this magnitude at this time.
Are you aware that any of the interveners have articulated a basis that current estimate is inaccurate, either too high or too low?
I do not recall any testimony or any party positions that the current cost estimate is inaccurate or too low.
And Mr. Pascucci, has the company supplied information that supports that current cost estimate through this proceeding?
Yes, I believe we've provided the studies as part of Mr. Kelly's supplemental direct testimony. We've provided updated budget spreadsheets. I believe attachment GJK2 to Mr. Kelly's testimony provides some updated budget estimates as well there.
You're asked some questions about other projects, and the questioning was along the lines of a 12% accuracy rate. Is each project unique?
Yes, I would say each project's unique, and what I attempted to show in my rebuttal testimony is while they are unique and every project is different, when the company conducts generation projects, our track record is positive. We've saved significant sums on our construction costs for customers. I believe the number I provided was approximately $243 million in cost savings on construction costs. And while they are not perfect comparisons, I believe it is a much more apples to apples comparison than a transmission project to a generation project.
Also wanted to ask you, you were asked some questions about the PIM. Does the PIM and the cost cap reflect the company's acknowledgement of the increase of the cost estimate from the original to the current one?
It does. By setting the baseline at $80 million instead of 87, which is our proposed budget, the company is effectively taking on some risk that in order to not incur a penalty or to achieve an incentive, the company needs to avoid spending any risk reserve identify additional cost savings from its base budget, and reduce its AFUDC cost. So for the company to earn an incentive would be, I would say, fairly difficult. We'd have to have no unknown risks occur, or we'd have to find cost savings to offset those. We would have to find cost savings to offset AFUDC, or in-service the project early enough to avoid a significant AFUDC cost. And we would have to find just basic savings on what our baseline budget of $76 million is. So achievement of an incentive is not easy here. And the company is taking risk that should it be late and incur additional AFUDC costs, should our cost estimate be wrong, there is risk that the company will not only incur a penalty, but may not recover its costs.
And were those concessions in the settlement agreement in direct response to the concerns raised by the commission and the interveners?
Yes, they were in direct response to both intervener and commission concerns. What I think I would note is that this PIM also provides a reasonable opportunity for the company to achieve an incentive. It's very difficult, but it is possible, while considering that if the company is wrong again on its cost estimate, we will pay a penalty. But doesn't, as I said in my rebuttal testimony, as staff's initial proposal had proposed, doesn't result in a penalty simply for us achieving our baseline $76 million construction budget. Under staff's PIM, as we read it, we would have incurred a penalty simply for spending what we thought, based on a CPCN quality estimate, it might take to do the project.
Mr. Pascucci, I think you made it fairly clear. Specific questions about the outage schedule or resource adequacy, that'd be better addressed by the company's engineers who are here today.
Yes, those are very good questions for them.
Just a couple questions, or maybe one more question. Do any of the questions or the issues raised change your position on behalf of the company that the settlement agreement is reasonable and in the public interest?
No, I believe when viewed holistically, looking at how the performance incentive mechanism, all three pieces tie together, looking at the provisions around timing and operations, that all of that really makes this settlement in the public interest. It's a collective compromise amongst parties who had very different positions between direct, supplemental, direct, and answer testimony. And we all reached a position where we balanced the various interests here.
Your Honor, may I have one moment?
Yes, you may.
Thank you. No further questions. Thank you, Your Honor.
All right, thank you for your testimony. You may step down.
Thank
So I
you.
will say you're not completely released yet, but for now, your testimony is concluded.
Thank you, Your Honor.
Is the company ready to call its next witness?
Yes, Your Honor. At this time, the company will call Harold Kelly.
Okay. Mr. Kelly, if you'll raise your right hand with me, do you swear or affirm the testimony you will give in this case will be the truth? Right, go ahead and take a seat and state and spell your name and try to speak into the microphone.
Gerald Kelly, Gerald.
Okay, thank you.
Judge, I'm sorry, I'm having trouble hearing Mr. Kelly.
Gerald Kelly, Gerald, Kelly.
Mr. Kelly, by whom are you employed and in what capacity?
XLNE to support the Piesco conversion project.
And did you submit direct testimony, supplemental direct testimony, and rebuttal testimony in this matter?
I did.
Okay. Did you have a chance to review that testimony in preparation for the hearing today?
I did.
And would you give the same answers that were set forth in that testimony if asked to testify today?
I would.
Okay. Your Honor, for the record, Mr. Kelly's testimony has been previously admitted as hearing exhibits 102, 104, and 106. Mr. Kelly is available at this time to answer Your Honor's questions regarding the flexibility of PONI and any additional questions regarding the heat rate.
Thank you.
And I'll just remind you, Mr. Kelly, please speak into the microphone.
Yeah, see if you can pull that a little bit closer. Okay. All right, and I'll just note for the record that no other party has indicated that they wish to ask you questions. So with that in mind, I'll proceed to the questions that I have. I asked Mr. Pascucci a couple of questions that he said either you or Mr. Bogner would be better answering. So I'll go through all of those. And if you want to defer me to Mr. Bogner, that's fine as well. Just let me know, okay?
I will.
All right. All right, so I can start back with this, one of the hypotheticals I asked. And that is, let's assume that Pawnee is successfully converted to gas in time for the summer of 2025, and that the company at that time does not have additional renewable resources from the ERP and CEP phase 2 that are online by that time. Under this hypothetical, how would Pawnee's conversion impact the company's operations?
That question is best answered by Mr. Bogner.
Okay. And then the next question would be, in this hypothetical, does the company anticipate that it will be able to integrate more renewable resources during the summer of 2025 than it otherwise could if Pawnee had remained coal-fired?
Also best answered by Mr. Bogner.
So then the next question has to do with plant functionality and flexibility. Once Pawnee is converted, how much time do you anticipate that it will take for Pawnee to reach minimum and maximum load?
The conversion and the boiler study came to the conclusion that no major components would need to be replaced. The boiler tubes, the fans will remain. And so because that massive steel still exists, the times to start up to minimum maximum will be similar to what the coal plant requires today.
And can you tell me what it is that the coal plant requires today?
I don't know. I don't have those numbers. I'm sorry.
Is that something I should ask Mr. Bogner?
He might not either.
Okay. Does the company anticipate having a firm gas contract in place once Pawnee has been converted?
That question is either best answered by Mike Bogner or someone in the gas group for Excel.
Just give me a moment. I think that might have been the questions. But I just want to double check to make sure I didn't miss anything. Yep, that's all the questions that I have for you. Any redirect? No redirect. Okay. Thank you, Mr. Kelly, for your testimony. You may step down.
Thank you, Your Honor.
At this time, the company will call Mr. Bogner to the stand.
Okay. Hi, Mr. Bogner. If you could raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
I do.
All right, go ahead and take a seat. Make sure that microphone is on and speak directly into it. State and spell your name for me.
My name is Michael, Michael, Bogner, Bougghner.
Your witness.
Mr. Bogner, by whom are you employed and in what capacity?
I'm employed by Excel Energy Services, and I'm the Director of Power Operations.
Did you submit rebuttal testimony in this matter?
I did.
Did you have a chance to review your rebuttal testimony before today's hearing?
Yes.
Okay. Would you provide the same answers today as you provided in your rebuttal testimony?
Yes.
Your Honor, for the record, Mr. Bogner's rebuttal testimony has been stipulated as hearing exhibit 107. He is now available for Your Honor's questions.
Okay. And I'll also just note for the record that no other party indicated that they wish to cross-examine Mr. Bogner. So I will, it is appropriate for me to go ahead and ask my questions. So Mr. Bogner, I've just got a couple questions for you. I'm sure now you've heard my hypothetical a couple of times, so hopefully you're going to be able to answer it for me. So this has to do, this is a hypothetical about capacity issues. So let's assume that Pawnee is successfully converted to gas in time for the summer of 2025, and that no additional renewable resources from the ERP CEP Phase 2 are online by the summer of 2025. Under this hypothetical, how will Pawnee's conversion impact the company's operations?
It should not impact operations through the summer in terms of reliability or resource adequacy. The capacity of the unit will be the same post-conversion. So as long as the conversion is complete in time for the summer season, it should not change our capacity position at all.
And under this hypothetical, does the company anticipate that it will be able to integrate more renewable resources during the summer of 2025 than it otherwise could if Pawnee had remained coal-fired?
I think it's safe to say that it will not make a material change in the renewable resources that we could integrate during the summer if any of those projects are ready to start construction or complete construction by that time. For the reasons that I think you just heard Mr. Kelly speak to, that the general characteristics, the operating characteristics of Pawnee are not expected to change materially after the conversion. And so it would really be a change in the flexibility of that resource that may have an impact on our ability to integrate more renewables. And without an expected change in flexibility, I don't anticipate any material change in our ability to integrate renewables.
Okay, thank you. So Mr. Kelly just testified that the company anticipates it will take approximately the same amount of time for Pawnee, once it's converted, to reach minimum and maximum load as it does presently with Pawnee being coal-fired. Is that your understanding?
That's my understanding as well, yes.
And do you have any information on how much time that is?
Yeah, based on current operations, startup at Pawnee typically takes anywhere from 48 to 96 hours or more. It really depends on the chemistry in the boiler as they're going through a startup and required holds that take place as they're bringing the unit online to allow chemistry to stabilize in the boiler. And post-conversion, it's my understanding anyway that none of the characteristics of the unit that influence those required startup operations or holds will be changed. So we anticipate that startups will likely still take at least 2 days, if not longer.
So you refer to startup, and I just want to sort of unpack that a little bit, because really what I'm trying to figure out is how much time to reach minimum load and then how much time to reach maximum load. Can you connect the dots for me on that with the startup times you just gave me?
Yeah, so if we're just talking about moving between minimum and maximum load once the unit's online,
yes.
We also don't anticipate that there will be any material change to the ramp rate of the unit, the ability of the unit to ramp up and down between its minimum and maximum load capability. So yes, I'm sorry, I may have misinterpreted your question. I was speaking more directly to the time to start up the unit once it's been cycled offline if we shut it down. But I also don't anticipate that there will be significant changes to the unit's ramp rate once it's online.
And do you know what the unit's current ramp rate is for reaching minimum and maximum load?
I can't say with specificity here exactly. I think it's in the range of 3 to 4 megawatts a minute. And it also depends on at what level we have the unit loaded. So that's typically the case. That ramp rate really applies to the range of operation between 300 and 505 megawatts or full load. We can ramp the unit down to as low as 200 megawatts and put the boiler in what's termed hibernation, which requires slower ramp rates to ramp down and back up to 300 from that lower 200 megawatt level.
Okay, thank you. And so that 48 to 96 hours that you're referring to is sort of the startup time. What happens once it's at startup? What is the system ready to do? Is that when the ramping begins essentially?
Yeah, so a startup is really defined as the time from, the point in time where we make a decision to start the unit back up after it's been offline to typically that would be to when the unit reaches minimum load at either 200 or 300 megawatts in this case. However, those chemistry holds I spoke to for Pawnee require that the plant go through a process to ensure that it can safely and reliably ramp to max load after it's started and reached minimum load. That's a little bit unique to that unit. So there is a longer period of time for startup that takes into account the time required to be able to, from a offline condition, be able to ramp that unit to max load, if that makes sense. Once they've completed that process, then the 3 to 4 megawatt a minute ramping I spoke to from that point on, once it remains online, can take place.
Okay, thank you for that clarification. Very helpful. Let me I think I've got another question. Some of the other witnesses may have attempted to answer this, but I figured I might as well ask you. Will the company have a firm gas contract in place once Pawnee is converted?
It is my understanding that our intention is to firm up the gas supply to that resource. It's not a firm contract right now, but we will be putting in place a firm contract for gas supply once it's converted to recognize the fact that we currently have a firm source of fuel for the unit in coal. And for this, in particular, winter reliability, we need to make sure we've got a firm contract post-conversion as well.
Okay, thank you. All right, let me just double check my notes to make sure I've covered everything. All right, those are all the questions that I have for you. Any redirect?
No redirect, Your Honor. Thank you.
All right, Mr. Bogner, that concludes your testimony for now. You can go ahead and step down when you're ready.
Thank you.
So we've got about 12 minutes before noon. Do the parties want to go ahead and push through with the next witness, which I think is Mr. Gribb, or we could break early, then we would just come back early. Any preferences? And you know what, I guess I ought to ask staff, since Mr. Gribb is staff's witness, Mr. Santisi.
I think it would be helpful if we just take advantage of this time. I'll introduce Mr. Gribb, and he'll be available for questioning.
Okay, go ahead and call him.
Okay. Staff would like to call Mr. Adam Gribb.
Hey there, if you could raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth? All right, please have a seat. Make sure that microphone is on, pull it close to yourself, and state and spell your name for me.
My name is Adam Gribb, A-D-A-M, Gribb, G-R-I-B-B, boy.
Great. Counsel, your witness.
Okay, thank you, Your Honor. All right, Mr. Gribb, could you briefly state who your employer is and what your responsibilities were in this proceeding?
Yes, I am a staff and engineer on the Fixed Utility Department of the State of Colorado Public Utilities Commission.
Okay, great. Were you paying attention, present, listening to the testimony that's been sponsored by the company this morning?
Yes, I was.
Okay. And are you, does staff endorse the company's responses to the questions that were asked this morning?
Yes, we do.
Okay. And is it, the staff has an opinion as to whether the settlement is just, reasonable, and in the public interest?
Yes, staff believes the settlement is just, reasonable, and in the public interest.
Okay, Mr. Gribb is available for questioning.
All right, and I don't believe that any of the other parties have indicated that they have questions for Mr. Gribb, which means that, oh, you know what? You're correct. I'm sorry. I think I was just looking at a different witness name. So the UCA has some cross-examination, and we've got about 9 minutes. Why don't you go ahead and get started, and then we'll recess at noon.
Good morning, Mr. Gribb.
Good morning.
Mr. Gribb, on direct examination just a moment ago, you testified that staff endorses the testimony provided by the company earlier this morning. Is that right?
That is correct.
And you were present when I was questioning Mr. Pascucci from the company earlier this morning.
That is correct.
And so similarly, I have some questions for you regarding your testimony here today that you believe this settlement agreement is in the public interest, okay?
Okay.
And prior to providing the testimony today, you provided sworn written testimony in this proceeding.
That is correct.
And in that sworn answer testimony, you provided your portion of staff's recommendations for the commission regarding the issues in this proceeding.
That is correct.
And I say your portion because your colleague, Erin O'Neill, also provided sworn written testimony sort of for her portion of issues.
That is correct.
And Mr. Gribb, you're testifying today as staff's lead witness.
Correct.
And as lead witness, you're able to provide information contained both in your testimony as well as Ms. O'Neill's answer testimony.
In general, yes, but there are probably some specifics that would be best addressed by Ms. O'Neill.
And when you provided your answer testimony, you were providing staff's sincerely held recommendations on what the commission should do with the issues presented by this case, correct?
Correct.
And likewise, in her portion, Ms. O'Neill also provided staff's sincerely held recommendations about what the commission should do with the issues presented in this case.
I believe so, but you'll have to ask her.
Okay. Well, and staff is one entity, correct?
Yes.
Okay. You and Ms. O'Neill both work for staff.
Correct.
And you're testifying here today to advance staff's position regarding the settlement agreement.
Correct.
One of the central concerns that staff had with the company's application was the near doubling of cost estimates from the original estimate provided in the ERP, correct?
Correct.
And in the sworn answer testimony, staff expressed a general concern about how project estimates provided by the company can swing dramatically in amounts of tens of millions of dollars.
Correct.
Ms. O'Neill noted in her testimony that this Pawnee conversion project was originally selected through the ERP scenario by modeling it against alternative ERP portfolios.
Okay.
Would it refresh your recollection to look at a copy of Ms. O'Neill's testimony?
Yes.
If we could pull up hearing exhibit 701, please. Oh, I'm sorry, page 11 and specifically lines 17 through 20.
Okay.
Okay, and that's in fact the concern that Ms. O'Neill representing staff shared, is that the conversion project was selected through the ERP scenario modeling against alternative ERP portfolios.
Correct.
And it was in fact selected because its original cost estimate of 44 million was considered cost effective when considered against alternative portfolios.
Correct.
And in providing this sworn answer testimony, staff did not raise these concerns because they believed that the $44 million estimate that was approved through settlement in the ERP proceeding was just a rough guesstimate provided by the company, correct?
You would have to ask Ms. O'Neill that. I was not part of that settlement or essentially even aware of it until this proceeding.
When you provided your sworn answer testimony, you raised concerns about increased costs.
Absolutely.
And you knew those were increased costs from a $44 million estimate.
Correct.
And you did not believe that that $44 million estimate was essentially a rough guesstimate provided by the company.
I have no idea of how the company developed that number. That was just the number that I started with.
Okay. Is that research that you undertook and before preparing your written answer testimony?
I started with what was on the application and what was answered in discovery.
Okay. You didn't at any point go back to the 2021 ERP proceeding?
I don't believe I did.
And when you provided that sworn answer testimony, you didn't believe that $44 million estimate was just a rough number that the company had poorly communicated was in fact not to be relied upon.
I don't have any knowledge of where that number came from essentially.
And with respect to, you say you don't have any knowledge, but it sounds like you're aware that that number came out of an ERP proceeding that you didn't participate in.
Correct.
Nothing would have prevented you from going into the record from the ERP proceeding to learn about those circumstances before preparing your sworn answer testimony in this proceeding.
Correct.
And what you did note in your answer testimony is that you were struck by the company's lack of project design work, or I think what you classified as project management work, or PMW.
Yes.
Is that right? And you associated the lack of PMW to the near double current cost estimate of the project.
Can you show me?
Sure.
Reference that? Please?
If we could pull up hearing exhibit 700, please, page 8. I'm sorry, lines 9 through 18, if you don't mind taking a look, Mr. Gribb, and let me know when you've had a chance to review that.
Okay.
Okay, and you were concerned about the lack of project or PMW as it related to the current cost estimates in this proceeding.
I don't see that in that section.
Okay. Well, in your answer testimony, you would agree that you were critical and pointed out the difference between what you would expect to see in terms of project design work versus what the company actually provided in their application.
Yeah, but can you point that out to me, please? Where?
I could have just a moment. If we could go to hearing exhibit, or I'm sorry, this hearing exhibit, page 10, lines 5 through 11. Oh. I'm sorry, I think I've misspoken. Sorry, page 9, line 13.
Okay, that says I classified it as a conceptual estimate.
You classified this application as a conceptual estimate and you gave it a class 4. Is that right?
Correct.
Okay, and then if we could turn to page 12 and line 16, please. Lines 13 through 16.
Okay.
Okay. And in that part of your testimony, you explained that you would expect to see the minimum information and detail required by staff to accurately review the status of a CPCN application like this one as a class 2 level
Correct.
planning, correct?
Yep.
Okay, and
Okay,
these classes,
Are we going to be at a good stopping point soon? Because we're after 12 already.
this isn't okay stopping.
Okay,
place.
sorry to interrupt.
That's fine.
Okay, so it's right about 12:03 right now. We'll go ahead and take our lunch recess. I'll give you all the full hour. We'll be back at 1:03, and I'll remind everyone the webcast will continue during our recess. So you can go ahead and step down during our recess, and we'll pick back up with your testimony then. It will be in recess. All right, so before we officially go back on the record, I just want to check in with my court reporter.
I'm ready.
All right, we'll go back on the record. Where we left off, UCA was examining Mr. Gribb, but I don't see UCA's counsel who was doing that cross-examination in the courtroom.
Sorry, Your Honor, she's just in the restroom, I believe. She'll be right in.
Okay,
Thank you.
we'll just hold on a minute then. Counsel, when you're ready, you can pick up your cross-examination. Mr. Gribb, you're still under oath.
Thank you.
I apologize, Your Honor. I thought my timing was off. Thought we had a few more minutes.
It's okay.
Mr. Gribb, I want to back up. Good afternoon now.
Good afternoon.
And just talk about this idea that you're testifying as the lead witness for staff this afternoon. What does it mean to you to be the lead witness for staff?
So I hadn't really thought about that. Can you give me a second?
Sure.
I guess the lead witness would be responsible for the major details, with other witnesses who could fill in other questions that other parties or the ALJ might have.
Okay. And what did you do to prepare for your testimony here today as staff's lead witness?
I reviewed my testimony and the consent agreement, and then I reviewed Mr. Neal's testimony.
Mr. Neal's
Yes, Mr. Chris Neal's, and I did briefly go over Miss Erin O'Neill's. Yes.
Okay.
I would not say I'm familiar with either one of them, as familiar as I am with my own.
Sure. And did you review any commission decisions and orders that had been issued in this proceeding?
Not this weekend. No.
Okay. And when you prepared your written testimony, your answer testimony, I think you said earlier that you reviewed the application in order to prepare your written testimony.
I don't recall saying that, did I?
Well, did you, when you prepared your answer testimony, what did you review?
I did review the application and the direct and supplemental direct testimony. Yes.
Okay. And the direct and supplemental direct testimony of the company's witnesses. Okay. I just want to make sure we're on the same page. And then I had asked you earlier about a statement in your written testimony articulating staff's concerns about the doubling of costs And then I think I misdirected you within your own testimony.
Correct.
Let me ask you, do you remember providing testimony expressing concern about the doubling of cost estimates in this case?
In general, yes, but can you point to that specifically?
Sure. If we could pull up hearing exhibit 700, and this time page 17, please, at line 5.
Okay, yes, I see that.
Okay. And so that the doubling of the cost estimates was a concern that you had.
Yes.
Okay. And is it fair to say that in your answer testimony, you discussed that concern about the doubling of cost, and you also discuss your concern about the level of planning provided in the company's application?
Correct.
Okay. And that's what we were discussing before we broke for lunch. Does that sound right?
Yes.
Okay. And we talked about how staff would expect a class 2 level of application, but what you determined the information provided by the company in their application was more akin to a class 4 level of planning.
That is correct.
Okay. And these levels are created by the Association of the Advancement of Cost Engineering, or ACE. Is that right?
Correct.
Okay. And ACE promulgates classes that indicate what phase a planned engineering project falls into.
Correct.
And the ACE guidance, or the ACE provides guidance about what level of planning one would expect to see based on the breadth and cost of a proposed project.
Correct.
And the level of planning was particularly concerning for staff because in your evaluation of company CPCN projects from 2011 to 2018, you found that there was less than a 12% chance that any given project would be completed on time and on budget.
Correct.
And staff was concerned that the company's historical lack of design, timeline, and cost accuracy in CPCN projects led to CPCN projects being approved before the required amount of project management work was completed.
Correct.
And this analysis, this 2011 to 2018 analysis, that is reflected in an exhibit that you attached to your testimony. Is that correct?
Correct.
And specifically a chart that you created that's listed as AMG 5.
Correct.
Okay. And just to be clear, you filed AMG 5 with your answer testimony into this case.
Correct.
Okay. And along these lines, what you noted is that staff expected the project management work for this Pawnee conversion to take on the characteristics of a class 2 project, correct?
Correct.
And in fact, that expectation that staff had was in line with Department of Energy policy, which requires class 2 level of project design work for decisions relating to projects over 100 million.
That is correct.
And that number is important because the project proposed here is approaching that DOE threshold of 100 million.
Correct.
And for projects that are classified as class 2, you would expect to see in an application complete design information developed.
Correct, yes.
Detailed labor, material, and subcontractor costs.
Correct.
The detailed plan would then provide a meaningful control against which to measure actual costs.
Correct.
With class 2 projects, you would expect a maturity level of project definition deliverables at 30 to 75% maturity.
That is correct.
And with class 2 projects, you would expect a cost estimate methodology that provides detailed unit costs with forced detailed takeoff.
Correct.
And importantly, when we're talking about cost containment, you would expect with a class 2 classified project, an estimated cost accuracy rate range of -5% to -10% on the low end,
Correct.
and positive 15% or plus 5% to 15% on the high end.
Correct, which is exactly what's in the settlement agreement. It's the base cost of 80 million plus or minus 10%.
Okay, and you're talking about the
Settlement agreement.
band.
Yeah.
Okay, and we'll get to that.
Okay.
And part of the reason when you provided your sworn answer testimony that you believed this project should be more along the lines of a class 2 project in terms of planning was that the company had 18 months to engineer, design, and develop the cost estimates for the CPCN application.
Correct.
And you believed it was reasonable to expect after 18 months that the company would have completed the design work up to the class 2 ACE standard.
Correct.
But what you classified instead, we mentioned this morning, was that this application came to you as more akin to a class 4 estimate.
Correct. And that's why we went through and exchanged the idea with the company in settlement to get staff to the comfort level.
Okay. Let's talk about class 4 estimates generally, okay? And then
Okay.
we'll talk about the settlement in a few minutes. Class 4 estimates are generally what you see prepared based on limited information.
Is that in my testimony? Is that in the attachment? I just want to make sure where's that at before I answer.
If we could pull up hearing exhibit 700 and page 11, and Mr. Gibb, this is your testimony, page 11, lines 6 through 7.
Is that me causing that feedback? Is anyone else hearing that, or is that just me?
I'm hearing it. I'm not sure where it's coming from.
It is very difficult to tell where it's coming from. I could hear it only out of the speaker, so. Your microphone is the one in the room that absolutely has to be on.
Oh, I think.
It's coming from up top.
Yes, that's what my testimony says.
Okay. And on this concept of cost containment, class 4 conceptual projects only have an accuracy range of -10% to 20% on the low end of cost estimates.
Yes.
And plus 20% to 30% on the high end.
Correct.
And it was the level of planning offered by the company in its direct case that warranted the class 4 designation from staff.
Correct.
Now, Mr. Pascucci testified on direct examination this morning, and you agreed with, in your testimony earlier this morning, that the settlement agreement has reporting requirements that will reporting requirements that will offer explanations as to some of the company's planning processes.
That is correct.
recall agreeing with that testimony?
Yes, I do
Okay.
recall.
Now in staff's own answer testimony, it made a different recommendation of reporting requirements to demonstrate company planning. Do you recall that part of your answer testimony?
In general, yes.
Okay. And specifically what you recommended, because you had articulated these concerns about the lack of planning in the company's proposal, is that you had recommended that the company provide within 90 days of any approval of the application, a list of the 29 ACE planning criteria items.
That's not exactly right. There are 74 in the document. I pared down the list to whatever it is in my attachment. And then in settlement discussions, we pared it down to the 3 or 4 or 5 or whatever is in there. Because I felt those are really important to make sure that, and I want to make sure I get this right.
Okay, well, let me stop you there, Mr. Gribb. What you wrote in your answer testimony as a recommendation is that the company be required to report on all 29 items completed to the level expected for a class 2 estimated project.
That is what I wrote, but as we went through settlement, and I can't tell you everything we discussed in settlement, that there were items that shouldn't have been on that list that I was unaware of. So when it got down to it, those were the important items to make sure, and I am going to say it this time, to protect, and as professional engineer, my primary obligation is to protect the safety, property, and welfare of the public. And those were the ones I felt were most important, and we're going to get them in fairly short order after a decision.
Okay. And Mr. Gribb, that ACE list includes 29 items that you wrote in your testimony should be completed for a class 2 project.
Correct, but
Okay.
again, in settlement, there was actually
Mr. Gribb. Hold
fewer
on,
than
Mr.
that.
Gribb. Let me ask you a question.
Okay.
These listed 29 items, in fact, you thought were important enough to ask the company about in discovery, correct?
Correct.
Okay, and you asked them to fill out a chart about what they had completed and what they hadn't in discovery.
That is correct.
And in your testimony, you noted that you had concerns about some of their responses, in particular, the company's concerns about certain things being, quote, not applicable.
Correct.
Okay. And that was what you provided in your answer testimony.
Correct.
These listed 29 items are things like providing permits. Would it be helpful to look at a copy of the list?
Please.
If we could pull up, it's hearing exhibit 700 AMG 1-1. And yeah, I think this is me.
Speakers.
Council, why don't you try your microphone at council table and see if we have the feedback?
Is this better? I think this might be better. Okay. And I'm sorry, I think where we left off, I was asking to pull up AMG 1 from hearing exhibit 700. And if we could just scroll down to the chart, please. And so, Mr. Grib, I had asked you, these ACE promulgated 29 listed items are for things like providing project permits, providing project drawings, providing equipment lists, things like that, correct?
In general, but specifically about the permits, I don't know if, and you would have to go into AMG 2 to see, but the permits may just be the application has been submitted. I don't have that level of detail off the top of my head.
Okay, but those are the things that ACE promulgates in their list.
Yes.
To ask for.
Yes.
Okay. And ACE, we talked about it earlier, but ACE is not a party to this case, right?
Correct.
What is ACE?
The American Association of Cost Engineers, or they may have changed the name to just AACE now, I'm not sure.
Okay, and it's sort of a non-partisan, meaning not a party to this case, objective set of standards for analysts like yourself to use as a resource. Is that fair to say?
Correct.
And in fact, you have used ACE standards in testimony in other cases, correct?
Absolutely.
Okay. ACE is the standards promulgated by ACE you think are valuable.
Yes.
Okay. And certainly you did when you provided written testimony about the ACE standards in this proceeding.
Correct.
And these 29 listed items, these are all things that staff believed were in the company's control to answer.
Yes.
Could it be that thing?
Yeah, I don't think we could turn that particular microphone off because it's tied into our streaming. But I'll just note, because it's not very clear and probably a transcript, that we're continuing to get some feedback that we're trying to resolve. Seems like it's from somebody's microphone. Why don't we just forge ahead and hopefully it won't be so bad. Meanwhile, we'll think about what we can figure out where it's coming from.
Okay. And under the ACE standards for a Class 2 project estimate, staff would expect to see 15 of the 29 identified items to be reviewed and approved as appropriate and completed at the outset, correct?
Correct.
When you conducted analysis of the company's application in this proceeding against that ACE 29 item list, you found that the company had only completed 2 of those items.
Correct.
And so applying the ACE standards, here the company's application fell short of the ACE planning standards for a Class 2 project estimate on the front end.
Correct.
And that's why you advocated in your recommendations for the company to be required to produce a PMW action plan that demonstrates their plan to complete all 29 action items to be completed to the level expected of a Class 2 estimate.
Correct.
And you advocated in your recommendations that they complete those 29 items within the first 90 days.
Correct.
Now, sort of contrary to that recommendation or distinguished from that recommendation is that the settlement agreement here does not have a reporting requirement where the company is required to plan or to report on all 29 of those ACE items within the first 90 days.
Correct.
Okay. And in fact, you mentioned a moment ago about your concerns about safety. The company pursuant to this settlement agreement does not have to provide reporting on safety planning until September 1st, 2024.
Is that in the settlement agreement?
Would it be helpful to take a look at, it looks like you have one
Yeah,
there.
yeah, if that's the date, yes, but.
Page six.
That may very well be 90 days after this proceeding is over, so.
Sure, so
So rather than say, again, I can't discuss everything that was said in settlement, this is what was agreed to by the parties to make sure that that information was provided to staff and in this proceeding.
okay, and in a hypothetical situation, if this settlement agreement were approved sometime in early 2024, the safety planning would not, that reporting would not be required pursuant to this agreement until September.
I can't predict the future of when commission proceedings are going to finish.
Okay, fair enough. The settlement agreement has planning terms that speak in sort of broader language than the 29 discrete planning items identified in that ACE list, correct?
No, I'll say no.
Okay, well, let me give you an example. That ACE list that we just displayed had planning items like piping discipline drawings as one of the items, correct?
Correct.
Or electrical schedules as one of the items.
Correct.
Okay. Whereas the settlement agreement here requires reporting on broader topics like, quote, breakdown of major tasks.
I think you're conflating a few things here.
Mr. Gribb, let me direct your attention to page 6 of the settlement agreement. I think you have it in front of you on the
I have it in
screen.
front of me, yes.
Okay, and you would agree with me that one of the reporting requirements created by this settlement agreement is that the company report on breakdown of major tasks.
But that's not one of the 29 items.
Right, the settlement agreement does not list the 29 items from the ACE list, correct?
I'm sorry. What specific item are we talking about here?
I had asked you a moment ago about these 29 specific items in the ACE planning list. Do you recall?
Yes.
Okay, and that was what was displayed on the screen from a discovery question asked by staff.
Correct.
And you had asked the company in that discovery to go through those specific discrete items.
Correct.
And then after that, in your answer testimony, you recommended that the company be required to report on those 29 items within 90 days of any approved application.
Correct.
Okay. And now here we have a settlement agreement.
Yes.
And the settlement agreement does not have those 29 discrete items for reporting requirements.
Correct.
And it has reporting requirements on topics like, quote, breakdown of major tasks.
Yes, but breakdown of major tasks is not one of the 29 items.
You've answered my next question. Okay. And procurement schedule, the settlement agreement also has a reporting requirement for a procurement schedule of major equipment.
Oh, correct.
And you would agree that's not one of the 29 ACE items.
Correct.
The settlement agreement does not define what constitutes a major task.
Correct.
And likewise, the settlement agreement does not define what constitutes major equipment.
Correct.
And so it's unknown from the back end of the settlement agreement how the company's planned reporting will align with the 29 discrete ACE promulgated listed items that you recommended.
That I initially recommended, that is correct, but there are
okay.
1, 2, 3 of those 29 items are specifically listed in the settlement agreement, and those are the ones that are important to, and I'm going to quote myself again here, protect the safety, property, and welfare of the public.
Okay. So 3 out of 29 from an original 74.
Yes.
Okay. The concern about concern you expressed in your answer testimony about the company's lack of planning also impacted staff's original recommendation concerning the PIMS.
Correct.
And staff viewed a PIM as a complementary tool to get to a proper project management work.
Can you show me where I?
Sure, if that would be helpful. If we could pull up hearing exhibit 700, page 21, and it just at the top, Mr. Gribb.
Yes, staff views a PIM as a complementary tool to proper project management work. Yes, that's
Okay.
correct.
And the PIMS are something in particular your colleague, Miss O'Neill, provided testimony at.
Correct.
And what's important to staff is that if PIMS are to be used to complement a proper PMW, it's important that they adhere to articulated principles concerning PIMS.
Did I say that?
Do you recall reviewing the testimony of your colleague, Miss O'Neill?
I do, but I can't quote it. If that's in Miss O'Neill's testimony, you
Sure.
have to point me to that, but.
If that would be helpful.
But I would say that those questions are much better directed towards her than they are me.
Well, let me ask if we could pull up hearing exhibit 701, please. And page 8. And let me ask you this, Mr. Gribb, because I do think that you may know the answer. PIMS shouldn't just be sort of handed out willy-nilly, right? There should be some principles underlying the PIMS and the purposes they serve.
In general, yes, but I can't, again, that would be something that would be much better directed to Miss O'Neill than to me, as far as what the principles for these specific PIMS are.
Okay. Well, and what PIM principles state, really the purpose of the PIM is to actually provide an incentive for the company to behave a certain way.
Again, in general, yes, but as far as these specific PIMS, that's a question much better directed towards Miss O'Neill.
Okay. Well, it was these principles in mind about a PIM complementing a project management work that you wrote about in that testimony we just discussed.
In general, yes.
Okay. And it was with this in mind that staff originally recommended a baseline PIM of $67 million.
Is that mine?
If we could go to hearing exhibit 700 and page 21. And Mr. Gribb, this is your testimony.
Again, it was just, we've been hopping around and I'm just trying to make sure. I don't see, I see full details of staff recommended PIMS are approved or provided in answer testimony of staff witness O'Neill.
Okay, and what staff had proposed is a baseline PIM of the average of the ERP estimate and the current cost estimate.
Okay, I'll take your word for it for now.
Well, Mr. Gribb, that's not my word. That's what you wrote in your testimony, correct?
Where I asked you to show it to me and you gave me a page that's not on, so.
Mr. Gribb, I'm just going to direct your testimony or your attention to page 21, line 5. And
Oh, okay, yes.
And there you wrote, right?
Yes.
Okay.
I'm sorry.
Okay.
We've been jumping around, so I'm a little bit confused now.
Well, and we don't have to get in the weeds with testimonies. If you know the answer, feel free to answer. What staff recommended was a baseline PIM that represented the midpoint of the original ERP estimate and the company's current cost estimate.
Correct.
Okay, and that was what was proposed by staff in connection with your concern about a PIM being a tool to complement project management work, PMW.
Okay. Yes.
Okay, and that's what you wrote.
Yes.
Okay. Despite this well-reasoned recommendation, the settlement agreement here does not set a baseline PIM at that midpoint of 67 million, correct?
Correct.
Instead, the settlement agreement sets a baseline at 80 million.
Correct.
And that baseline is 36 million more than the original approved estimate of 44 million.
Correct.
And you talked about this a bit ago, but that settlement agreement provides a deadband for that PIM, is that right?
Correct.
Of 5%?
Yep.
And that goes in both directions.
Correct.
And so in this way, the settlement agreement actually permits the company to receive a PIM for costs up to $84 million.
Yes.
The settlement agreement allows the company to receive an incentive PIM for spending in excess of $40 million greater than that original estimate.
I'm sorry, I have to think about that. You said, could you repeat that, please?
The settlement agreement allows the company, and I'll back you up. We talked about that 5% dead band.
Yep. So,
And would you agree that goes up to $84 million?
yes.
Okay. And so the settlement agreement essentially allows the company to collect an incentive PIM for spending up to $40 million greater than the original estimate.
No, I don't agree with that. If the company spends $83,999,000, they're not going to get that's in the dead band, so they don't get anything in the dead band.
Okay. On the other side, the company will receive an earnings increase if they keep project costs below 95% of that $80 million baseline.
Correct.
Meaning that if the company spent less than $76 million, let's say $75.5 million, they would earn an earnings increase, even though that amount is $30 million greater than their original estimate.
That is correct.
Okay. And let me back up to my previous question. The company could spend up to $84 million without incurring a penalty PIM under the settlement agreement.
That is correct.
Okay. And going back to our earlier conversation about the level of planning staff expected to see in this application, there is no penalty PIM or penalty created in the settlement agreement if the company fails to provide sufficiently detailed reporting under that section of the settlement agreement.
That is correct.
Another concern that staff had concerning cost containment was that the proposal set forth by the company, as it was initially proposed, did not have any mechanism to cap project expenses.
Correct.
And so that's why you originally recommended, or staff originally recommended, an $87 million hard cap.
Correct.
And under that proposal, any costs in excess of $87 million would not be recoverable by assigning them to ratepayers, correct?
Correct.
And in making this recommendation, staff again noted the length of time that the company had had to plan this project.
Correct.
Here you would agree that the settlement agreement does not create the hard cap originally contemplated by staff?
I would say a qualified yes. I mean, you know, act of God should have, I probably should have included that. So, you know, can we ever have a true hard cap? I don't think so. I mean, that's just not the way the business world works.
Okay, you you advocated for what you call the hard cap.
Yes, yes,
And the settlement agreement is something different than that.
that is correct.
And it's for $88 million rather than $87 million.
That is correct.
And it does allow the company to recover if they can, in excess of $88 million, if they can establish the extraordinary circumstances exist.
That is correct.
And I think you've alluded to this, but the settling parties did not include language about what would constitute as extraordinary circumstances.
That is correct.
And as it's explicitly written, the settlement agreement does not preclude any of the 29 listed planning items from the ACE standards to be considered or to be petitioned for by the company as extraordinary circumstances.
Correct.
If I could have a moment.
You may.
I don't have any further questions. Thank you.
All right, so I do not have questions for this witness. Is there any redirect?
Very briefly, Your Honor.
All right, go ahead.
Good afternoon, Mr. Grip.
Good afternoon.
You just were asked many questions by the UCA that generally relate to the deviations between staff recommendations and the settlement agreement. Would you agree to that characterization?
I would.
Okay. As we sit here today, generally speaking, what kind of information is a utility required to provide with respect to a CPCN application? And as you answer this question, if you could please look at the settlement agreement, specifically page 6, section 5, subpart B.
You'll have to give me just a second, please.
It's also on the screen to your left.
Okay. I do want to cross-reference one thing, if that's okay.
If you're going to be reviewing a document other than the exhibit that council directed you to, we need to make a record of what you're looking at.
Okay, then I'm going to be looking at my own testimony.
Which exhibit number is that?
Exhibit number 700.
Okay.
What I will say in general is this is much more detailed than is generally required for a CPCN. CPCNs generally require some basic costs, verification that the noise and electromagnetic fields are deemed reasonable by the commission, and that's really about it.
Without divulging, confidential settlement discussions, either internally or with the company, is the staff generally satisfied with that list that you're looking at, subpart B in the settlement agreement on page 6?
I will say yes, that this captures all the project management work that staff will ask for within 90 days. We're going to get it within 90 days. And some of the specific safety items, we have a date certain that we will receive it.
Okay, thank you. Do you recall fielding a question about the PIM from council?
Yes.
Okay. Would you agree that one of the commission principles is as it relates to a PIM is symmetry of cost treatment?
Yes.
Okay. Is this PIM symmetrical?
Yes, it is.
Isn't it asymmetrical, actually? the PIM that was agreed to in this proceeding?
This is symmetric. It's the deadband is symmetric on both sides. Okay, I'm sorry.
As to the cap.
As to the cap, no, it is, you are correct. It is asymmetric. There is a upper limit.
Okay, there's an upper limit. Okay. I have no more questions for Mr. Gribb, so thank you.
Okay, Mr. Gribb, that will conclude your testimony for now. Thank you. Is staff going to be calling Miss O'Neill?
Your Honor, staff was not intending on calling Ms. O'Neill unless, of course, you have questions for her.
I do not have questions for her. I don't think anybody identified her as a witness they would like to examine. So.
Staff will not be calling. Ms.
Okay. All right, and then I think we've already addressed the witness that was listed for the Conservation Coalition. So let's turn to the UCA.
Good afternoon, Your Honor. UCA will call its witness, Mr. Chris Neal.
All right.
And while Mr. Neal is getting ready, I just wanted to address a point you made earlier, and I overlooked it, was that we did not specifically designate any direct time for Mr. Neal to express UCA's opposition to the settlement agreement. So I apologize for that. But we did state in our filing of our witnesses and our exhibits that Mr. Neal would testify relating to UCA's opposition to the settlement agreement.
Okay, and I'll just say for the record, I do really want to hear from the UCA about its objections. So, and then I'll also note for the record that we had a similar issue involving public services first witness. So I think it's perfectly fair to allow the UCA's witness to the UCA to put on some direct for this witness.
Thank you, Your Honor.
All right, Mr. Neal, when you're ready, come on up to the witness stand. All right, if you'll raise your right hand with me, do you swear or affirm the testimony you will give in this case will be the truth?
I do.
All right, go ahead and take a seat. Make sure that microphone is on and pulled up close to you, and then state and spell your name for the record.
My name is Chris Neal, CHRISNEIL.
Thank you. And counsel, before I turn the witness over to you, do you have an estimate as to how much time you're going to need for his direct?
I would say 35 minutes, between 35 and 45.
Okay, all right, you can begin when you're ready. I'll just remind everybody that the plan is to take a recess at about 3 o'clock. So everybody just keep that in mind.
Thank you. Mr. Neal, could you please state your employer and your job title?
I'm employed by the Utility Consumer Advocate. I'm a rate financial analyst.
Did you prepare and cause to be filed hearing exhibit 500, answer testimony of Chris Neal on behalf of the UCA in this proceeding?
I did.
And did it also have attachments CN1 through CN3?
Yes.
They've already been admitted, so we don't have to address that issue right now. Have you had an opportunity to review hearing exhibit 108, the settlement agreement entered into in this proceeding by Public Service, Trial Staff, Natural Resources Defense Council, and Sierra Club?
Yes.
Does UCA oppose the settlement agreement?
Yes.
Does UCA also agree with some sections of the settlement agreement?
Yes, in the spirit of compromise, the UCA is agreeable to many sections of the settlement agreement, but we are opposing certain sections of the settlement agreement.
Thank you, and I will walk through those next. Is it okay if we pull up hearing exhibit 108? And I am going to be starting on page 2. Does UCA agree with the cost PIM that was agreed to in the settlement agreement? It's addressed in section 2A.
UCA agrees with the use of a cost PIM, which is a change from my testimony, but we don't agree with the baseline of $80 million in the settlement agreement.
Why does UCA recommend that the commission reject the $80 million baseline?
This is partly because of the same reasons that staff recommended something else. UCA recommended use of staff's number of $67 million. And this is also the same point that the commission raised in moving this case to an ALJ, that they were concerned with the doubling of cost and wanted to see a PIM that used an appropriate baseline that would not give a bonus to the utility for doubling those costs. And this PIM does not qualify for what the commission requested.
Okay, let's unwrap that a little bit. So just to make it clear, is UCA recommending that the commission adopt a baseline of 67 million?
Yes.
And that's based on the reasoning set forth by staff in Ms. O'Neill's testimony, is that correct?
Yes, based on Ms. O'Neill's testimony and also the directive from the commission.
Let's pull up Ms. O'Neill's testimony. It's hearing exhibit 701. And let's go to page 14. Lines, I can't see very far from here, but I'll direct you, Mr. Neal, to lines 1 through 4 on page 14.
Yes, again, here she says that part of the reason for the PIM is to account for the change in the original estimate from 44 million to nearly double that now. And I also want to point out that another reason is because of the doubling or the significant increase in project costs from Fiasco in other cases, including generation project cases.
Okay, let's turn to page 20 of Ms. O'Neill's testimony. Going through lines 3 through 8, Mr. Neal, would you agree that the testimony where Ms. O'Neill's staff is merely reflecting on the project history and the general company history of large increases in budget between phase 1 of the ERP and the actual CPCN applications? Does that reflect what you were just referring to?
Yes, and it also reflects my table CN1 in my testimony, where I provided several examples of significant increases in costs from the original estimate to the final cost from Fiasco projects.
Would you also agree that UCA endorses staff's baseline of 67 million to avoid the attended circumstances of the company bearing no risk or consequence for the doubling of the project budget estimate after receiving approval of the coal action plan and the ERP?
Yes, this is consistent with what Ms. O'Neill said and the commission directive to that the company should not receive not have any penalty for the costs that are significantly higher than the original estimate.
Okay. Does UCA oppose the baseline and the cost containment PIN for any other reason?
Yes. It doesn't provide a significant incentive or penalty, or it doesn't provide enough of an incentive to, quote, change the behavior of the company, which is one of the directives that was established in the Power Pathways, one of the principles from Power Pathways that are also cited in Ms. O'Neill's testimony.
Would you provide some examples of why you think that it doesn't provide significant enough incentive?
Well, yes, we've said that if the actual cost reached $84 million, that's their $80 million baseline plus the 5% deadband is $84 million. That's $40 million above the original price, and that would result in no penalty to PSCo. Another example is if the price reached $87 million or $88 million, the cap, that would only be a $400,000 penalty, which is, as we said, not enough money to provide an incentive for the company to change the behavior. Under our proposed $67 million baseline, if it went to $84 million, there will be a $1.7 million penalty because that's $17 million over the $67 million price. If the actual cost was $88 million, that would result in a $3 million penalty under our proposal instead of, as I said, $400,000 for PSCo or for the settlement baseline.
Do you have any comments relating to the recommendation of UCA and how it affects the sharing of the risk between customers and the company?
But yes, those penalties are examples of sharing. Basically, there's minimal sharing of the cost overrun between the company and customers in the settlement PIM, whereas for example, if the cost was $88 million, the sharing would be about $40 million plus for customers and $3 million for PSCo. That's at least some sharing of the cost overruns.
Thank you. Let's move on to the next section of the settlement agreement. The proposed cap of 88 million. Actually, it's in section 2AI. Do you see that?
Yes.
Does UCA agree with that?
Yes. Again, in the spirit of compromise, we agree with that.
And what about the extraordinary circumstances language that's been discussed a lot so far today? Does UCA agree with that language?
No, that is too ambiguous. We'd like to have more specificity. Something like COVID, the things have been mentioned already, something like COVID, a pandemic, or an act of God. Someone mentioned a tornado, and a tornado going through Pawnee would certainly be a reasonable act of God that would allow an extraordinary circumstances, but not just if the cost goes up, and that is not what that is intended to mean.
So does UCA recommend a modification to the settlement agreement that defines extraordinary circumstances to include acts of God, COVID, and the like?
Yes.
I think Your Honor this morning came up with a recommended phrase. Let me see if I can find it. Would UCA agree with language such as circumstances beyond the company's control that were not reasonably foreseeable?
Again, I worry about that they would claim that includes something like just a supply chain increase and things like that, which is not what is intended, I think. So it needs to be more something really unexpected, like we say, a pandemic or an act of God.
Unexpected and outside the company's control?
Yes.
Right. Does UCA agree with the 5% as the dead band? And that's in section 2A, little 2I? I don't know how do you refer to that instead of little i's? Romanettes. Okay, thanks.
Yes, UCA agrees with the 5% dead band as long as the baseline is $67 million.
So if it's set at 80 million, why doesn't UCA agree with that?
Well, because again, you would have to go to more than 84 million or more than 40 million above the original cost before there would be any penalty to Fiasco.
All right, and moving on to the next section, the 10% penalty incentive for costs over or under the baseline plus or minus the dead band. Does UCA agree with that provision?
Yes.
Is that true if the baseline is at 67 million?
Yes.
If it's at 80 million, does UCA agree with that?
Well, we don't agree with the $80 million baseline, so we basically don't agree with it.
Okay. Does UCA agree with the incentive in the settlement if public service were to come 95% below the baseline?
Yes.
All right, let's turn next to the timing PIM, which is in section 2B. Does UCA agree with providing the company with incentives to finish the projects before 1/1/26?
No.
Could you expound on that, please? Tell us why not.
Yes, a lot of it is discussed in my testimony, and even public service has testified that there's a concern for reliability. And I expand that to not only reliability, but the cost if they try to do the conversion early. I'll point out that public services had, as I recall, 2 proceedings last year in which they had to have special circumstances to add capacity that they had not anticipated. One was adding capacity at the Thunderwolf and Neptune solar projects. And I'm sorry, I can't remember the numbers in these proceedings. I think that was 22A-0563E, but I can't remember. And the company also had another case where they added short-term resources, again, on a very short-term basis because they were short of capacity. So there's a real concern that they won't have enough capacity. As I said in my testimony, the planned amount of reserves in 2025 are only 26 megawatts. And it's, I think, 151 megawatts in 2026. So there's a very narrow margin. If anything happens, they won't have enough capacity. I'm not sure that included the capacity in the EDR case, which is 0330E, 22A-0563E, which had well over 100 megawatts of additional capacity. And when public service ran the ERP cases, they added scenarios with new capacity. And I think those scenarios had 300 megawatts of new capacity coming online. And the hint was that was really going to be there. So it's very difficult to say that they will have enough capacity to do this conversion before 2026. And that's just the reliability issue that public service has pointed out. But there's also the cost issue. I said it shouldn't be converted unless the renewable resources are there. They were originally planned to be there and result in low cost to replace the capacity. And cost is a huge concern for UCA. All the existing renewable resources will be used to the maximum extent available. So if you convert public service, you're not going to be, if you convert Pawnee, you're not going to be using existing renewable resources to replace Pawnee's generation. If you want to have a low cost conversion, you need to have new renewable resources. That was the original plan. but there just didn't turn out to be any new renewable resources in 2025. And even some of them in 2026 may not be available as planned because they just got delayed because the ERP has run so late.
I have two follow-ups to that, Mr. Neal. First of all, can we pull up hearing exhibit 500, Mr. Neal's answer testimony, and go to pages, start with page 11?
And Mr. Neal, I'd like to just remind you to try to slow the pace of your speech a little bit for our court reporter's sake.
Oh, I will try.
Good. Okay, Mr. Neal, does this page of your testimony, I think, yes, starting at line 3 through the bottom of the page, reflect what you were just discussing, the concerns you have about starting the conversion or converting Pawnee prior to the fall of 2025?
Yes, and I want to point out that the reliability short concern is something that could happen. I did not say it will happen, but I said it could happen. But they, as I said, they need to go to, or as they get closer, to review the resources they have to make sure they're not short of capacity, make sure new load hasn't come on. 2 years ago, that they decided to convert it by 1/1/26, and you don't just go blindly ahead and do that and not evaluate what has happened after that. Have they lost resources? Have they had what they planned to have happened happen? The resources they planned to have addition, did those resources actually get added? You need to review that and make sure you can reliably convert this plant at a reasonable cost of replacement power.
Thank you. And did you hear Mr. Pascucci's testimony this morning? Were you here for that?
Yes.
Did you hear the part of his testimony that addresses this recommendation by the UCA?
Yes, as far as I go, he agreed that you need to make sure you can do this reliably.
Reliably? Okay.
And I added that low cost as well, not just reliable. Because the UCA is the cost cop. We're the ones most concerned about saving costs for customers.
Do you have anything else to say about the settlement agreement PIM that relates to the timing of the conversion?
No, I think I've said that.
Okay. Let's move on to the next section. There's a recommendation for the performance. It would be the unit efficiency PIM addressed in section 2C.
Yes, the heat rate PIM, I would call it.
Okay. What is UCA's position on the settlement agreement's heat rate PIM?
Well, we think a performance PIM is a good idea. We don't think the heat rate PIM is adequately adequately structured, and there's too much left, unspecified. The base heat rate is not specified. I'm not a boiling engineer expert, but I have looked at hundreds of heat rates for power plants. I've modeled heat rates for power plants in models. And for example, a typical heat rate for a plant like Pawnee is about 10,500 BTU per kilowatt hour. A 5% deadband puts that between, I think, 9,975 and 11,025. And that's basically the entire range of performance of a power plant, the heat rate of a power plant. It's very unlikely to go up beyond that or less than that. So I think the 5% deadband is too wide. It doesn't really provide a real incentive to PSCO to do anything. So that needs to be reevaluated based on factual data, and not set by a bunch of regulatory people who are used to setting dead bands at 5% for everything. You know, that doesn't really set the performance for the power plant. I also wanted to point out that this morning, Piesco let us know that it takes 48 hours to 96 hours to start the plant up and get to minimum output. And I just wanted to make it clear that the plant is burning fuel for those whole 48 hours to 96 hours without any generation coming out. There's no kilowatt hours coming out. That's a lot of fuel and has a huge adverse impact on the heat rate of the plant. So if you start it up a lot of times over a year, you're going to have a bad heat rate. If you don't start up a lot of times over the year, it won't be as bad. You contrast those 48 hours to 96 hours to a combustion turbine, and a combustion turbine will pop on in an hour. It doesn't have nearly as much wasted fuel like a plant like Pawnee does. And that's why I've said, you've got to determine when Pawnee is going to be needed for a long time, because you start it up, it takes a long time to start up, and you have to run it for a long time. It can't just turn off the next day or, after a couple hours of generation. So you need to run it when you're going to have to run it for a week or so. That's why I say a long time. I mean a week. That's what's needed to decide when to run Pawnee as opposed to when to run a combustion turbine.
All right, thank you, Mr. Neal. The next section of the agreement addresses how to process the credits or company incentive awards. It's section 2D. Do you see that?
Yes.
What's UCA's position on that section?
We're okay with this, with the 10-year recovery.
Okay. Do you see paragraph E? And I think it goes into the next page. Will you take a minute to read that, please?
Okay.
Do you agree that the settlement agreement is generally consistent with the commission's principles for PIMs?
No. Again, the commission laid out several principles that are repeated in Ms. O'Neill's testimony, and the $80 million baseline is not consistent with those principles. It doesn't provide a significant enough incentive to change the behavior of the utility, which is one of the principles from that decision. And it doesn't provide a reasonable sharing of the costs between customers and the company. The penalty is just too small in the settlement proposal.
Let's walk through the principles that you were referring to in Ms. O'Neill's testimony. Hearing Exhibit 701, pages 8 and 9.
Can you go back up just one line or two to get I wanted to show decision number C 22A-0463E. Is that what it says? So I just want to make sure that's, the commission decision in the ERP phase 1. And these are the principles that the commission identified for PIMs. And because they were putting a PIM in the ERP,
well, let's walk through each one of them. The first one is the PIM should establish penalties or incentives that scale with the degree of success or failure. Do you think that the PIM set forth in the settlement agreement satisfy that requirement?
No, not with it being set at $40 million over the cost that was approved in the, or cost that was used in the ERP.
The next is that it should not be excessively lucrative. Do you agree that the PIMs, or do you think that the PIMs in the settlement agreement are consistent with that requirement?
Can you say where you're actually reading that?
Yeah, here.
I don't see excessively lucrative.
It's a part of one of the,
Oh,
yeah. So I'll go to the section.
I just thought we were going down the number by number and
Yeah,
I think you skipped to,
I did. It's in paragraph number 5.
okay.
The PIM should establish penalties or incentives that scale with the degree of success or failure in achieving the predefined metrics, but should be neither excessively punitive nor lucrative and must be in conformance with existing law.
Yes, I agree with that. And I don't agree that this penalty, well, this penalty is certainly not excessively lucrative, but it has minimal punitive action.
If the commission were to approve the 80 million baseline and apply the PIM based on for the cost containment PIM and apply the baseline or apply the PIM based on that $80 million baseline, do you think that would be excessively lucrative?
To a certain extent, yes, because that means Piesco gets like $40 million and with, at most a risk of a $400,000 penalty.
Okay. I'll go back to number 2. The PIM should clearly and unambiguously focused on one or a small number of objectives that are not already the subject of an alternative performance incentive mechanism or pre-existing utility incentive.
Yes, that one's okay because this is focused on the cost of the Pawnee conversion.
Create the ability for all parties to clearly and unambiguously identify success or failure on the basis of a predefined baseline.
Yes, that's the PIM is structured reasonably in that respect.
Okay. The company should have control over factors determining its success or failure.
Yes, and that's where the cost is under Piesco's control. And if there's an act of God or something like a pandemic, they have the right to bring it to the commission for recovery.
And that's if the settlement agreement clarifies the definition of extraordinary circumstances.
Yes.
Okay. Number 6, we already went over 5. Number 6, the PIM should establish penalties or incentives that are of a large enough magnitude to supersede other factors, e.g. return on equity that influence company behavior.
Yes, this is where there's a problem because the settlement PIM is not large enough to influence company behavior.
Okay, and is that in the above and below the baseline?
Yes.
And are you specifically talking about the cost containment PIM as we
Yes.
walk through these? Okay.
With the $80 million baseline proposed by in the settlement. And I think with the $67 million, there's at least, a chance that it will influence company behavior.
Okay. And then the last one articulated in Ms. O'Neill's testimony is paragraph 8, the PIM should complement and inform utility performance evaluation.
Yes, that's fine.
Okay, thank you. Let's pull up, it was marked as UCA Exhibit 501, and I think Judge Mirbaba has allowed it to come into the record, but we haven't had to identify it as an exhibit since it's an order from the commission that's been filed in this docket.
Yeah, that hasn't been admitted because it is part of the record, but you can certainly use it for illustrative purposes and asking this witness questions.
Thank you. Mr. Neal, can you identify the document that's on the screen?
Yes, this is the decision in this proceeding referring the matter to the ALJ and including some of the commission's concerns with this proceeding.
Is it decision number C23A-0365-I?
Yes,
And was it mailed on June 6, 2023?
yes.
Let's go to paragraph 17, please.
You're going to need to identify page numbers.
Oh, okay. Oh, sorry. Page 7, paragraph 17. Starting in the middle of the paragraph, Mr. Neal, would you read starting with "We are interested"?
We are interested in the parties addressing the establishment of the correct cost baseline for a potential PIM that would not result in rewarding public service for cost savings beginning from a point substantially higher than the previously presented cost estimates relied on the commission in its phase 1 decision. And I thought I also should read the top one. It says the doubling of the cost of the conversion.
No. Your attorney gets to ask the questions. You don't get to do whatever you want.
Okay. Mr. Neal, do you think that the settlement agreement as proposed is consistent with the commission's request here and recommendation here for the correct cost baseline?
Absolutely not. It says right here, the point should not be substantially higher than the previously presented cost estimates.
Do you think the $67 million baseline and the cost containment PIM is consistent with that?
It is more consistent.
As long as we have this pulled up, let's go to paragraph 19. Will you read paragraph 19 for us? I think each section of it has some relevance to what we've been talking about.
Fine.
Do we really need to have him read it out loud into the record?
No, Your Honor. If you would prefer that he doesn't, then I won't ask him to do that.
He could read it to himself and then you can ask him questions if you like. I mean, this is in the record.
Okay. Mr. Neal, will you read paragraph 19 to yourself? Tell me when you're done.
Yes, I've read it. And you're right, there are several points in it that are worth discussing.
Well, let's start at the bottom and move up. So do you think it says the commission requires accurate information when making resource decisions, and then the commission is welcoming party input and avoiding any potential for bait and switch and cost estimates over time. Do you have any input for the commission on how the commission could avoid any potential? The commission refers to it as bait and switch. I don't necessarily agree with, or you may, I don't. Anyways, do you have any recommendations for the commission?
I'm going to object to the question. I think the purpose of this witness is to contest the settlement, and obviously there needs to be some leeway. We were very patient, but we're now getting to the place where the UCA is just trying to put in additional evidence here. If they object to the settlement, that's fine, but to go ahead and testify as to a commission decision and their opinions as to what should be done is way beyond contesting the settlement agreement.
Any response?
Yes. The settlement agreement was entered into within the last month or so. And the parties didn't have an opportunity or chose not to provide written settlement testimony, either supporting or objecting to the settlement agreement. And UCA does object to the settlement agreement. And it is important for UCA to have sufficient evidence in the record that outlines the reasons that it opposes the settlement agreement and has an alternative proposal. So UCA is going through some of the reasoning underlying the opposition to the settlement agreement through Mr. Neal's testimony, which includes the instructions given by the commission when it referred the proceeding to an ALJ.
So I'll just say I was very unclear on what your actual question was. So for now, and for that reason, I'm going to overrule the objection. I didn't hear a question that tied this paragraph of the decision to the UCA's position on the settlement agreement. So I'm going to ask you to just re-ask your question and perhaps in a more direct manner that connects it to the settlement agreement.
Sure. Mr. O'Neill, or Mr. Neal, in reviewing paragraph 19, does that inform the UCA's opinion as to why it opposes the settlement agreement?
Yes, as the commission said there, we are concerned about potential for bait and switch. And here is one example where the commission or the company said the cost of this plan is 44 million, and then they switched to 80 million or even more. There's another extraordinary example in my attachment CN3, which is the 120-day report that was just issued a month ago. We were expecting certain amount of cost, just vastly more than any kind of indication. And I think that's the mission or realized in Piesco's massive transmission grab in the ERP.
Is there any other, anything else in paragraph 19 that you would like to reflect on that supports UCA's opposition to the settlement agreement in this proceeding?
Well, as it says, independent power producers, have to stick with their bid price. And that means they can't double the price, as the commission says in that paragraph, whereas Piesco has doubled the price of this project. As shown in my table CN1, they've doubled the price of several of the transmission substations that are associated with the ERP. It's just not an even playing field between developers and Piesco, and it needs to be a more even playing field. And I think the commission is pretty clear that that needs to be there need to be incentives to keep public service under control, especially given all the costs involved in the hundreds of millions of dollars in projects in the upcoming ERP. This is associated with ERP, and the next one is even worse.
I'm going back to the settlement agreement, Exhibit 108. I think the last section I wanted to address with you was the reporting section. Were you here for Ms. Crampton's cross-examination of Mr. Gibb?
Yes.
What is UCA's position on the reporting section of the settlement agreement?
Again, in the interest of compromise, we're okay with the reporting requirements.
Okay, I think just the last thing I wanted to do, Your Honor, is just make it clear for the record, the sections of the recommendations that are included in UCA's answer testimony, Exhibit 500, that UCA is no longer advocating on behalf of because of the testimony of Mr. Neal today relating to the settlement agreement.
Yes, go ahead.
Okay, thank you. Could we, oh, sorry, could we pull up exhibit 500, please? Starting on page 14. Line 21. The section is entitled Summary of Recommendations.
Yes,
The first recommendation relates to, the question is on lines 21 and 22. What's UCA's recommendation regarding the final cost of the Pawnee gas conversion project? And your answer begins on page 15, line 1.
yes, we're changing that to now agree with the cost cap of $88 million as in the settlement.
And what about the baseline?
Yes, again, we recommend a baseline of $67 million as proposed by staff.
The next recommendation relates to a PIM for the Pawnee gas conversion project, lines 4 through 7.
Yes, we now agree with a cost PIM for the Pawnee conversion project as proposed in the settlement.
Just to make sure we're clear, does UCA recommend the cost PIM as in total as proposed in the settlement?
No, with the $67 million baseline.
Okay. What about UCA's recommendation for Pawnee's operations starting on line 8?
Again, I continue to support that it should be operated as a high-cost peaking unit with a low capacity factor. That is probably the way the company is going to operate it, but I want to emphasize that and make sure they don't just run it like they have run Cherokee 4, which has been run way too much.
Going to line 11 through 17, your recommendation for flexibility to convert Pawnee prior to the fall of 2025. Does UCA continue to support that recommendation?
Yes, we continue to support a recommendation that it not be converted before the fall of 2025 and continue to oppose the early conversion PIM.
So that goes to your next recommendation, lines 18 through 23. What does UCA recommend for the timing of the conversion?
As I just said, we support fall of 2025 and oppose the timing PIM.
All right, I have nothing further. And Mr. Neal is available for cross-examination.
Who's going to be handling cross-examination on behalf of the company?
I will, Your Honor. Your Honor, I know it's a little earlier than your break. Some of the items we're hearing for the first time this afternoon. So I was wondering if we could take a short recess earlier than what you anticipated, and if you'll indulge me personally, I'd like to take a short break.
Yeah, I don't have a problem with that. It's about 2:35 right now. Well, no, it's 2:37. Okay, let's be in recess until 2:50. We are in recess.
Yeah, I haven't heard it since you sat down. A little bit right after, but not anymore.
Maybe it's just the lectern microphone. And the sound is so much better, guys.
So Harriet, since I hear you, does that mean you are ready to go? Harriet?
Sorry, I'm ready.
Okay. On the record, and counsel, you may begin examination.
Thank you, Your Honor. Thanks for your indulgence on starting the break a little early. Good afternoon, Mr. Neal.
Good afternoon. Could I ask if your microphone is on?
Yes, sir. Can you hear me?
You were a little weak.
I'll speak up. Is this better?
I suggest moving closer to the microphone. That's better.
Can you hear me now?
Yes.
Good. This afternoon is the first time that we've heard the UAC.
UCA.
Excuse me, the UCA set forth their positions on a settlement in
Yes.
terms of, for example, the $67 million.
Yes.
Now, you've reviewed the testimony of the company that it's filed throughout this proceeding, have you not?
Yes.
And you're familiar with the construction costs set forth in the revised or the current cost estimate by the company of $76.5 million.
Yes.
And you haven't identified any aspects of that current cost estimate that are inaccurate.
No, not specifically, but I don't have a lot of confidence in it, given that the last estimate was 44 million.
But you haven't identified any of the line items that support the $76.5 million and identified them as either understated or overstated, correct?
No, have not.
And you haven't identified any parts of the cost estimate that you believe that are too high or too low.
No.
And you haven't identified any of the line items that support the cost estimate that describe activities that either do not need to be performed for the conversion or materials that do not need to be purchased in order to complete the conversion, correct?
Correct.
And in that same vein, you haven't identified anything that you believe is missing from the cost estimate that would potentially increase that cost, correct?
No.
And besides reviewing the testimony and the exhibits that the company has set forth, UCA, thank you, has had the opportunity to serve discovery and ask questions or seek information in addition to what the company's provided in order to take a closer look at the figures that the company has set forth in its current cost estimate, correct?
Correct.
You just testified that the UCA would support a PIM for $67 million. Now that's in contrast to your testimony that you provided in this matter where the UCA did not support any PIM, correct?
Correct.
And to talk more about the PIM baseline that you proposed at the $67 million, that is not based upon any estimate that demonstrates that the conversion could actually could occur at that cost.
I disagree. It was based on both the $44 million estimate of the cost of conversion and the new cost of conversion.
And what you did is you looked at Miss O'Neill's testimony and you support her position that splitting that number in the middle for $67 million is fair.
Based on Ms. O'Neill's testimony and the commission's directive to direct a baseline that does not unduly reward the company for a much higher cost.
But Mr. Neal, you're not aware of any estimate, study, testing that would demonstrate that the conversion can actually be accomplished for $67 million, correct?
Objection asked and answered.
Overruled.
You may answer the question.
I disagree with that statement. The 44 million was an estimate of what it actually costs to convert Pawnee.
So you have two pieces of information that support your PIM baseline, the first estimate and the current estimate.
That's how that number was arrived at.
Okay. I understand that UCA is also revising its cost cap figure from the $83 million set forth in your testimony to now agreeing to the $88 million that it's in the settlement agreement. Do I understand that correctly?
Yes, as I said, in the spirit of compromise, we're trying to agree to as much of the settlement as we can. So there's as little as possible for the commission to have to decide and argue about.
Let me ask you a couple of questions about the PIM principles that your UCA's counsel pointed toward, directed you to in Miss O'Neill's testimony. If we could pull that back up, it was Exhibit 701, page 8. Bottom half of the page. You were asked about these principles, and principle 4 states that the company should have control over factors determining its success or failure. But Mr. Neal, you haven't seen anything that would indicate that the company can actually complete the conversion of the project for the PIM baseline you suggest at $67 million, and you don't take issue with any of the current cost estimate set forth by the company at $76.5 million.
As I've already said, the company initially said that the conversion could be accomplished at $44 million, and that's under their control. And I might point out that Fiasco converted Cherokee 4 from coal to gas a few years ago. That should have provided a good example of how much it's going to cost to convert Pawnee. There's no reason for this discrepancy to be of this magnitude, given the experience with Cherokee 4.
If we turn to the next page, Principle 5 talks about that the PIM should establish penalties or incentives that scale with the degree of success or failure in achieving the predefined metrics. Do you see where I'm reading from?
Yes.
Again, if the cost of Pawnee conversion now is $76.5 million, at least for the construction related costs, not to mention AFUDC and the risk reserve, the baseline that you propose almost guarantees a penalty at the $67 million. Would you agree with that?
Almost is the operative word, as Fiasco testified this morning. They are able to achieve a incentive.
I'm sorry, say that one more time.
Fiasco testified this morning that there is a possibility that they could build a plant for less than $76 million and achieve a Incentive, did I say penalty? I meant incentive.
But the baseline that you're proposing is $67 million. And there's nothing that indicates, besides it being a midpoint between 44 and the current cost estimate, that the conversion can actually be accomplished at that cost.
And I'll point out 67 plus 5% deadband.
I want to ask you some questions about the timing. You talked about the concerns you had on the timing of conversion. Do you acknowledge that the application and even the settlement agreement sets forth that the timing of conversion would only be advanced prior to the January 1, 2026 deadline if the company believes it can reasonably do so while maintaining system reliability, resource adequacy, and the cost reviewed by the commission?
Yes, as I've said, there needs to be reliability concerns and cost concerns, and I'm concerned about both of those.
And if those can be addressed by the company, then you don't have any concerns with them proceeding with conversion before the January 1st, 2026 date.
As I said, I think that needs to be reevaluated. I'm not confident at all that it can be done for both reliability purposes and cost purposes.
You don't suggest a plan otherwise, though. You just don't have any confidence the company can do it.
Well, I think the otherwise is doing it in the fall of 2025, just like it's planned to be done.
Let me ask you some questions about the operations. You talked or provided some testimony about how Pawnee should be operated as a high-cost peaking plant and not base loaded. Do you recall that?
Yes.
Now, this wasn't an issue that UCA raised in the ERP Phase 1 settlement agreement, correct?
I don't think so.
UCA was a party to that settlement agreement, correct?
Correct.
And they placed on no conditions on how Pawnee would be operated once it was converted.
I think this is the reason for this is the recent example of Fiesca running Cherokee 4, which is another gas steam plant that was converted from coal to gas and running it extensively. So in our recent case, we were seeing Cherokee 4 running for the entire 5 months of the fall when another unit was out. And that's just not the least cost way to run a plant like this. That's not a prudent way to run a plant like this.
With your answer testimony or any of the evidence, there's nothing submitted by UCA in terms of studies or engineering analysis on the appropriate way to operate Pawnee after conversion.
This is the normal way to operate Pawnee after conversion. There's nothing special about this.
Okay.
It should be operated at a high-cost plant because it is a high-cost plant.
Mr. Neal, you really need to slow down.
Just sticking with operations, did you read Mr. Bogner's testimony?
Yes.
And part of his testimony talks about the variability of renewable energy, if you recall that.
Yes.
And one of the things that Mr. Bogner testifies to is that there's 5,400 megawatts of renewable capacity on the system, with 4,000 megawatts of that being variable. He also talks about the company only has 2,000 megawatts of flexible peaker generation that can be dispatched quickly. Do you recall that?
I don't actually recall those numbers, but something like that.
And these are all issues that need to be considered in terms of having dispatch available in order to meet load or capacity that's necessary, correct?
Yes.
And what we're seeing here is that renewable energy is going to increase in terms of that being what the company relies upon to service customers, right?
Correct.
So having firm dispatch is also critical in order to ensure that there's energy available for customer use, because renewable energy is variable.
Correct.
Your answer testimony took a look at the 120-day report and some of the long-term planning that was referenced in the ERP phase 1. Do you recall that?
Yes.
A couple of items that weren't addressed in your answer testimony is medium-term procurement and short-term procurement, correct?
Yes.
And you'd agree that prudent short-term unit commitment, a prudent short-term unit commitment plan has to incorporate some degree of flexibility to account for unforeseen changes in demand forecasts, renewable forecasts, and generator availability.
Well, that's the difference between this unit and other units like combustion turbines. This unit has to be committed. That means it has to be started 48 to 96 hours before you need it. Whereas a combustion turbine, you pop it on an hour before you need it. And that commitment decision is the major differences between this unit and the other one. And that's why you've got to use smart dispatch smart commitment that looks at the forecast of load and renewable resources and decides whether you're going to need this plant for a whole week or so, and then decide to start it up in that instance.
And in Mr. Bogner's testimony, he goes through all those variables and factors, and that's what the plan does in terms of its medium-term and short-term procurement planning.
If he actually does that and doesn't just run it the whole 5 months of the year like they did with Cherokee 4 in 2022.
And you've been critical before of the company's short-term capacity plans, right?
Yes.
And if they're short on capacity, they potentially have to purchase. Is that right?
Or acquire new resources on a very short-term basis that usually ends up being higher cost.
So they have to have Pawnee available if necessary in order to dispatch needed energy if renewables are not available, correct?
Yes, they have to commit Pawnee ahead of time to have it be available to actually operate, unlike combustion turbines, which can be popped on immediately when they're needed.
Your Honor, may I have a moment?
Yes.
Just a few more questions, Mr. Neal. You mentioned Cherokee 4. You'd agree it was built to run on gas.
No, it's a coal plant that was converted to gas, just like Pawnee is proposed to be converted from coal to gas.
Are the Cherokee 4 operations reviewed in ECA prudence review case?
Yes.
Okay. Does the company maintain in those proceedings it is operated in a manner it is due to, quote, must run transmission instructions?
Yes.
No further questions, Your Honor.
All right, I'll just note that no other party has indicated they wish to cross-examine Mr. Neal, so I will proceed to ask some questions that I have for you. So I want to talk to you about the concept of a hard cap versus what's been described as a soft cap that's in the settlement agreement. As I understand your answer testimony, you were recommending a hard cap. Do you still recommend a hard cap?
Well, again, in the spirit of compromise and improving as much as possible in the settlement. We're proposing the same cap in the settlement, that it's kind of the expanded soft cap where it's capped unless there's extraordinary circumstances, but we need a more specific definition of extraordinary circumstances such as pandemics or act of God.
Okay. So while we're talking about some of the changes in the UCA's position that you've outlined, I did just want to clarify one of those because I might have just written it down wrong. And so I just want to make sure I got it right. I thought when you testified that you said you supported a $76 million baseline. However, when you were just answering questions, I think it might have been clarified that you support a $67 million baseline, which was proposed by staff in answer testimony. Can you just clarify that for me?
Yes, I'm sorry if I disposed or imposed the numbers. It's 67 million in staff's testimony is our recommendation now.
Okay, thank you. So I understand one of the bases for the UCA's opposition in general had to do with the change in the original estimated costs as opposed to the estimated costs that have come through in this proceeding. And that was about a $40 million difference. So I'm wondering though, if the company's original estimated costs were in line with the current estimated costs, would how would that impact the UCA's position?
I don't know that we would have signed on to the settlement if the cost had been $80 million. And I don't know that the commission would approve the conversion of Pawnee if the cost was $80 million. You know, that is so much more than what it was initially portrayed at. You know, it was initially portrayed as a very low cost option to get gas-fired capacity and reduce emissions. But the $80 million is a much different basis. It's just, you know, not the kind of slam dunk that the $44 million was. So I just don't know that we would have signed on to the settlement.
And you're referring to the settlement agreement in proceeding number 21A-0141E?
Yes.
Okay. And so it sounds like the UCA's objection isn't just about the timing of getting this updated cost estimate to 88 million, up to 88 million. It's more substantive than that, if I understand correctly.
Yes, the $4 million the Pawnee conversion was a very cost-effective conversion, a very cost-effective source of a gas plant. I don't know that there's been any testimony in this case that the conversion is cost-effective at $80 million. I think that's a major omission from the record in this proceeding.
So how do I consider what you just testified to alongside your earlier testimony that the UCA agrees to the cost cap of $88 million as set forth in the settlement agreement?
Well, as I said, that's part of the compromise with the settlement, and we're trying to agree to as much of the settlement as possible.
So as you sit here today, the UCA is not really arguing against that $88 million in terms of it being a cost cap?
No.
Okay. Now I want to talk about your recommendations related to operational restrictions. Just for ease of reference, let's pull up hearing exhibit 500 and go to page 10. So starting at around lines 17. You say Pawnee should be run only when forecasts predict long periods of high loads or low renewable generation. And then near the bottom of that page, lines 22 to 23, the UCA recommends that the commission ensures that Pawnee is operated like a high-cost peaking plant with a low capacity factor after it is converted to natural gas. So those are still your current recommendations as we sit here today.
Yes.
Okay. So you would agree, though, that if the commission accepts your recommendations, that the company would be limited in its ability to make operational decisions about running Pawnee?
I don't agree with that. Mr. Bogner said that, and I call that stupid dispatch of the unit. And I'm proposing smart dispatch of the unit, that you don't just turn the unit on when you feel like it and run it, all kinds of times like they do Cherokee 4. You operate it when you've got a good forecast of high load or low renewable that requires Pawnee in addition to the combustion turbines and the combined cycle plants that are needed to operate to meet load in a reliable manner. I'm making sure that you operate the system in a reliable manner, and I'm not saying don't operate Pawnee when you need it.
Okay, but you would agree, though, that if the commission directs the company to only operate Pawnee as a high-cost peaking plant with a low capacity factor, then the company's choices are limited to only operating Pawnee in those circumstances. You agree with that?
And that's the only time it should be operated. Just like a combustion turbine. Combustion turbines have capacity factors well under 10%. Pawnee should not have a 20 or 30% capacity factor like Cherokee 4 does sometimes.
On cross-examination, you agreed that you had reviewed the company's rebuttal testimony that responds to this recommendation. And I think you spoke a little bit to my next question, but I just want to make sure I capture your complete answer. So I want to go ahead and direct you to the company's rebuttal testimony, which is hearing exhibit 107. Let's go to page 5.
And I'm sorry to turn this way. This is the only one I close enough for me to read, so I apologize for.
Perfectly fine. That's why we have that monitor up there. All right, let's see if we can get lines 15 to the end of the page on the screen there. So here the company testifies that these types of operational decisions are complex and involve assessing operational concerns every minute of each day of the year to select the appropriate mix of generation resources to maintain safe, reliable, and cost-effective service. Do you agree with this?
Yes, I agree with that. And I'm not suggesting that it be operated differently. As I said, should operated under a smart dispatch situation and not under a stupid dispatch operation, which they imply is what I'm saying. And that's not what I'm saying.
So how does the company account for having a large volume of renewable generation dependent upon weather under your proposal to restrict operations as we just discussed?
Well, as I said, you use the forecast of load and renewable generation to determine if Pawnee is going to be needed for, quote, I said a long time, and I mean like a week, which you've got to have a week because it takes 2 or 3 days to start the thing up. So, if you're going to exceed the capacity of the CTs and you need more generation, then you start up, you commit Pawnee to be operated. You commit Pawnee to be started so that it will be available when your forecast shows it will be needed.
So am I understanding correctly that it is not the UCA's position that the company should not have the ability to assess generation resources based on live circumstances to ensure it can continue to provide reliable service.
No, I basically agree that public service has to have the operational control, but they've got to be smart about how they operate Pawnee.
Are you aware of any precedent where the commission has imposed operational restrictions of the nature that you're suggesting here?
We bring this subject up, as I say, with the operation of Cherokee 4 in like every prudence proceeding. And we don't say the company should have different operational control, but we do complain about the cost and, you know, public service. They talked about the must-run status, and they determined must-run, which is they claim that there's a transmission state without any consideration of cost. You know, do you really need to have this must-run for 5 months? Did you consider that you only actually need it for 3 or 4 weeks out of those 5 months? That's just, you know, not actually operating it in the most cost-effective manner.
So you were just referring to ECA prudence reviews. So let's unpack that a little bit. Those are the proceedings in which the UCA has and could in the future continue to raise concerns about operational decisions that the UCA submits cost more than other operational decisions would have had. And essentially that's a way to challenge the company's recovery of such costs. You agree with that?
Yes.
And maybe more than that, but at the very minimum, this is an opportunity to challenge those decisions.
Yes.
And
they're hard to challenge after the fact. Usually the commission is not real big on imposing after the fact penalties.
Yes, and maybe in part, would you agree that that has to do with not applying sort of hindsight vision in making those decisions?
Well, that's part of the reason I point this out ahead of time. So we've established it ahead of time that they need to operate it in a cost-effective manner.
Okay.
So that we don't have to go back in hindsight and say, did you do this each hour and spent 5 months running a plant that should not be running for 5 months?
But even if the commission were to go with your recommendation, you would still want the ability to challenge the company's decisions in terms of operating Pawnee, right?
Correct.
And even if the settlement agreement is approved as written, the UCA and other parties would have the opportunity to challenge the company's decision-making in an ECA prudence review in terms of the operating costs.
Correct.
So I have some questions generally about the UCA's position in terms of the conversion timing. I know you testified earlier that you heard the other witnesses testify here today. Did you hear when Mr. Piscucci testified that he understood the UCA's timing concerns as being related to having replacement resources during the period of time in which Pawnee is expected to be out of service? Did you hear that?
That's what he said. I don't necessarily agree that that's the only issue to consider.
And that is why I am asking you.
Wonderful.
So please go ahead and clarify what really the UCA's objection is there in terms of timing.
Well, there's the cost of and reliability while the plant is being converted and is out of service, but there's also the cost after it's converted. So if, for example, you convert it in May of 2025, then you've got the next 7 months where it would be converted earlier than it would have if it been done in the fall of 2025. And therefore you've got, you know, this is now a gas plant, which has 2 or 3 times the cost of a coal plant. And you've got no new renewable resources to replace that plant. And that was the initial plan, was to have low cost renewable resources to replace that plant after it's converted. So for a few months, you have higher fuel cost due to this replacement. And right now we're involved in the case of Comanche 3, being out for, as I said, 5 months in the fall of 2022. And the replacement cost is $20 to $40 million, depending on whose position you take. But that's the kind of that may be the kind of additional cost we're looking at if this plant is converted in May instead of the fall, and even higher cost of replacement power if it's converted in January.
Okay. I just want to talk to you about the concept of replacement resources. Isn't taking the coal-fired generation of Pawnee and converting it to gas, isn't that replacement resources? I mean, doesn't the gas replace the Pawnee coal resource?
It replaces the capacity. It has then much higher energy cost. So you're also looking for new renewables to replace the energy from Pawnee when you do the conversion. And I point out, the existing renewable resources are going to have already scheduled to run the maximum they have. There's no additional energy from them to replace Pawnee. So you need the new renewable resources to replace the cost of energy from Pawnee. But yes, you're right. It's still 505 megawatts, whether it's on gas or coal.
I think I'm just still perplexed about why the conversion needs to be timed for when other replacement resources are available, given that the conversion is the replacement resource. I'm just confused about that.
Well, I try to say that there's the capacity. The capacity is fine. It's the energy that costs much, much more. And, Pawnee has a couple million megawatt hours a year. So a couple million megawatt hours at, say, $50 a megawatt hour for gas versus a couple million megawatt hours at, say, $20 a megawatt hour for wind and solar to replace that energy. So it's a much different cost of the energy to replace Pawnee's generation. Does that make sense?
Yeah. Are you suggesting then that renewable resources have to be ready and in place and operational before Pawnee's conversion?
That's the lowest cost way. And that's what I said in my testimony, that the timing of replacement should be timed for when the replacement capacity, meaning replacement renewable resources, are available to replace Pawnee at a low cost.
And was that a part of the settlement agreement in the ERP proceeding, that the renewable resources needed to be online before Pawnee could be converted?
That is not spelled out, but that's where I said, I think we anticipated that there would be renewable resources in 2025 to replace the energy from Pawnee. But even now, there are no renewable resources in 25 in the 120 report, and even some of the resources are scheduled for 2026 are questionable given the delays that we experienced.
As we sit here today, does the UCA agree that Pawnee should be converted to gas?
Yes.
And does the UCA agree that a CPCN should be granted for that?
Yes.
Why don't we go ahead and pull up hearing exhibit 302 Rev 1 and go to page 5. See if we can get lines 19 through 22 on the screen. So this is testimony from the Sierra Club commenting on your answer testimony. And the Sierra Club suggests that the UCA conflates conversion with retirement of the plant by implying that Pawnee's current capacity would not be available after the plant is converted, thereby resulting in capacity shortfalls under new renewables until new renewables are built in 2026 or new gas projects are in service in 2027. I think you might have responded to this somewhat already, but I just wanted to get a clear response from the UCA on the Sierra Club's take on the UCA's position on this issue.
I have several problems with the Sierra Club's testimony where she says what I said. If you want to see what I said, you should read what I said. I don't think I conflated anything. The capacity, as we just discussed, of Pawnee will still be there. It's the energy that I'm concerned about, the replacement cost of the energy and getting low-cost replacement energy from the renewable resources.
Okay, thank you. Let's pull up here in Exhibit 108, the settlement agreement. Let's go to, and then page 6. Let's scroll down to the bottom of the page. And here on the very bottom of this page, we start off the settlement agreements about the best value employment metrics, and that's Roman numeral 6. What is the, and this does carry over to page 7. If you would like to review that, my question is going to be, what is the UCA's position on this agreement term?
We don't oppose the BVEM part of the settlement.
So going back to some of the recommendations that you've made about operational restrictions, I'm wondering if you can tell me whether you think it's customary for the commission to establish operational restrictions on a specific or particular type of generation resource.
I don't think so.
Okay. And you talked about Cherokee 4, I think on cross-examination. Is there any evidence in the record related to Cherokee 4 that you can point me to?
Not in this proceeding.
I'm just going to take a moment here to make sure I've covered everything. How do you think, let's assuming that I or the commission decides to adopt the UCA's suggested modifications to the settlement agreement, how do you think that that could be accomplished, the modifications that the UCA suggests?
Well, our main modification is to change the baseline to the settlement, the cost PIM in the settlement to $67 million. And then take out so it's basically you write a different, you modify the settlement agreement for those changes to the settlement agreement and the PIMs, the cost one and the timing PIM, and talk about the heat rate PIM that needs to be refined.
Okay. Earlier, I think it was on direct, you talked about the extraordinary circumstances language in the agreement and that you think it really ought to be defined. And your attorney asked you whether you would agree with the description that came out during one of the other witnesses' testimony that I think I had summarized, which was unforeseen circumstances outside of the company's control that essentially could not have been reasonably foreseeable. And you said, I'm not sure you agreed with that. I think you made a reference to an act of God. So maybe you could just elaborate for me on what you think extraordinary circumstances should be.
As I said, I think that should be things like a pandemic or act of God, like a tornado hitting Pawnee. But, things like a cost increase from GE is outside the company's control, but that would not qualify. I mean, that's not an extraordinary circumstance. Costs go up all the time. Something like a war in Ukraine would be a extraordinary circumstances. We've had costs go up because of that, but it's got to be something like that, and not just the manufacturer increase the cost of equipment or something.
Sure, but part of that suggestion had been that those extraordinary circumstances were not reasonably foreseeable. I mean, it's not just that it's outside of the company's control. They would have to be unable to have planned for it and foreseen those extraordinary circumstances that have increased the cost. So do you disagree with that approach?
Yes, because I just worry that public service will put anything they want into that category, like, oh, the cost of equipment went up from GE. We could not foresee that. So, something like that. That's just because it's unforeseeable doesn't mean it's extraordinary circumstance.
Okay, so then how would you define that?
As I said, something like a pandemic or an act of God is basically what would be included in the definition.
Well, pandemic is an example. So it can't be a definition. So your definition would be an act of God, is that right?
That might be a good one.
Is there more that you would recommend in terms of the definition of extraordinary circumstances?
Well, if you put a pandemic in there, then that's an act of God. So that's what I put in for the moment. You might, write more in our SOP, but that seems what we're trying to limit it to things like that.
Okay. Great, we have covered all the questions that I have for you. Any redirect?
Yes, Your Honor, just briefly. Mr. Neal, do you recall the questions from Public Services Attorney relating to that were really questioning UCA's reliance on the $67 million baseline?
Yes.
Did UCA participate in the 22A-0563E settlement, where the agreement that the parties agreed to the 44 million and the commission approved that cost for the Pawnee conversion?
Yes.
So did UCA rely on that $44 million cost estimate for its recommendations in that proceeding?
Yes, I think the USCA relied on that $44 million as being a cost-effective way to obtain additional gas-fired capacity. And I think the commission very clearly said in its directive that they relied on that $44 million and they need accurate numbers for their reliance.
Do you recall the company just describing the $44 million cost estimate as a guess, just speculation?
That was not the portrayal in the ERP. It was, portrayed as a reasonable cost for that conversion and could be relied on. It was not portrayed as just a guesstimate that we shouldn't rely on and should just ignore and, make a decision based on it, but have no accountability for relying on that number.
Your Honor, I have nothing further.
All right, Mr. Neal, thank you for your testimony. That will conclude your testimony for now. All right, so that is the last witness that we had listed. Will the company be presenting any rebuttal evidence? Okay. So as of right now, I think that pretty much concludes the evidentiary portion of the hearing, except I do think we have a couple of outstanding exhibits that I'm hoping we can work through. And I'm going to turn to public service on that.
Thank you, Your Honor. I think we're prepared to address that in the company's box account. We have uploaded public attachments for GJK3 Rev 1 and GJK4 Rev 1. In addition, we have added the following exhibits per the discussion earlier today, which constitute the earlier decisions in the phase 1 case and those decisions and proceedings referenced in the company's testimony. If Your Honor would like, I can just move through those. There's 11 of them in total.
Let's just do this one at a time and start with the two that you just identified.
Sure.
So if my notes are accurate, that would be hearing exhibit 104, attachments GJK3 Rev 1 and GJK4 Rev 1. Stephanie, do we have those? All right, is there any objection to the admission into evidence of the two attachments to hearing exhibit 104 that I just identified? All right, hearing exhibit 104, attachments GJK3 Rev 1 and GJK4 Rev 1 are admitted into evidence. Let me just make a note of that before we move on to the next one.
No problem. Thank you.
All right, now let's turn to the next one. If you could identify it by exhibit number and then give me a description.
Yes. Next would be hearing exhibit number 109. It's the ERP phase 1 decision C22-0459 in proceeding number 22A-0563E.
Let's go ahead and see if we can get that pulled up on the screen. Are you sure about that proceeding number you just identified?
Yeah, sorry, the proceeding number is not correct. I apologize. The proceeding number it's 21A-0141E. My apologies.
I recognize that this is a rather long exhibit, but as I understand it, probably the majority of the parties here were parties to this document. Well, not really this document, but to the underlying settlement agreement that this decision addresses. I'm only raising that because it's 186 pages and I'm hoping that the parties will not need to review all 186 pages. Okay. Is there any objection to the admission into evidence of hearing exhibit 109? Right, hearing exhibit 109 is admitted into evidence. All right, let's hear the next one.
Hearing exhibit 110 is the ERP phase 1 settlement agreement. Same proceeding number 21A-0141E.
Now, is that the most recent? That's what I thought. I'll just note, I'm looking at the screen, it says non-unanimous partial settlement agreement is hearing exhibit 110. But I understood that there may have been an update after this one.
Your Honor, I believe we have the wrong one updated to the box account. We need to update, or we need to upload the updated settlement agreement, which we can take care of shortly here.
All right, well, we'll come back to that then. Let's go through the, identify the next exhibit number.
Next exhibit is 111, which is the coal cost recovery settlement agreement. Proceeding number 22A-0563E.
Stephanie, if you could just minimize this so we can see the title of this document. Is there any objection to the admission into evidence of hearing exhibit 111? Okay, there being no objection, hearing exhibit 111 is admitted into evidence.
Next, Your Honor, is 112, which is decision C23-0362. It's the coal cost recovery decision.
Is there any objection to the admission into evidence of hearing exhibit 112? There being no objection, hearing exhibit 112 is admitted into evidence.
Then, Your Honor, the remaining batch are decisions that were cited in the company's direct, supplemental direct, and rebuttal testimony. Exhibit 113 is decision C10-1328, which is the emissions reduction plan as part of the Clean Air, Clean Jobs plan.
Is there any objection to the admission into evidence of hearing exhibit 113? Hearing exhibit 113 is admitted into evidence.
Next, Your Honor, is exhibit 114, decision C180761, approving the company's Colorado Energy Plan in proceeding 16A-0396E.
Is there any objection to the admission to evidence of hearing exhibit 114? There being no objection, hearing exhibit 114 is admitted into evidence. How many more of these do we have?
We have 5 more.
Okay. Have any of the other parties had an opportunity to review those?
Your Honor, they have not. We loaded them over the lunch hour.
Okay, then let's just continue to go through them one by one.
115 is decision R220081. And actually, Your Honor, I guess to speed the process along, what I can represent is that the remaining 6 through 120 are all commission decisions that are cited in the company's testimony. 115 is decision number R220081.
Any objection to the admission into evidence of hearing exhibit 115? Hearing exhibit 115 is admitted into evidence.
Exhibit 116 is decision number C22-0234.
Any objection to the admission into evidence of hearing exhibit 116? There being no objection, hearing exhibit 116 is admitted into evidence.
Exhibit 117, decision number C22-0270.
Any objection to the admission into evidence of hearing exhibit 117? There being no objection, hearing exhibit 117 is admitted into evidence.
118, decision number C22-0430.
Any objection to the admission into evidence of hearing exhibit 118? There being no objection, hearing exhibit 118 is admitted into evidence.
119, decision number R20-0725.
Any objection to the admission into evidence of hearing exhibit 119? Hearing exhibit 119 is admitted into evidence. And I'll just note for the record that we are pulling up each one of these exhibits so that parties in the room can see what it is that's being offered. You can move on to the next one.
120 and the final exhibit, subject to going back to 110, is decision number C20-0886.
Any objection to the admission into evidence of hearing exhibit 120? There being no objection, hearing exhibit 120 is admitted into evidence.
And Your Honor, I'm informed that exhibit 110, the ERP updated settlement agreement, should now be correct. And subject to review on the screen, we would move its admission as well.
All right, let's get that pulled up. All right, is there any objection to the admission into evidence of hearing exhibit 110? Hearing exhibit 110 is admitted into evidence.
Your Honor, I believe that completes the additional exhibits Piesco would like to offer. Thank you.
All right, thank you. I am just going to run through the exhibits that we have admitted through the box.com process. In other words, the exhibits that were not listed on hearing exhibit 800. And those are the admitted exhibits are hearing exhibit 503, hearing exhibit 100, hearing exhibit 104, attachment GJK3 Rev 1 and attachment GJK4 Rev 1, hearing exhibit 109 through 120. Those have all been admitted. And then finally, well, it's not necessary, it just might be helpful. I want to have the hearing exhibit spreadsheet admitted into evidence, and that's hearing exhibit 800. Are there any objections to the admission of hearing exhibit 800? There being no objection, hearing exhibit 800 is admitted. All right, so I think that wraps up the housekeeping in terms of exhibits. All right, so I already previewed this, but I'll go ahead and repeat it now. In statements of position, I would like the settling parties to identify with specificity the parts of the application that are and are not modified by the settlement agreement. And I want to let you all know I definitely encourage the settling parties to file a joint statement of position, which to me indicates an agreement on such issues. And then I'd also like the UCA in its statement of position to clearly identify aspects of the settlement agreement to which it does not object. I think we went through a lot of that in testimony today, but it would be helpful to have that in one place in the statement of position. So I have that the statement of position deadline is December 7th. That's a full month from now. Unless anybody speaks up, I am assuming that nobody has any issues with the December 7th deadline, and we should leave it as is. All right, I'll note that nobody has raised any concerns with December 7th, and therefore that will remain the statement of position deadline. Before we adjourn, are there any other issues that we need to address? Okay. All right. Obviously, we have finished this hearing in one day. So the second day of hearing, which was reserved for this coming Thursday, will be vacated, though I will tell you, I think it's highly unlikely that a written decision will go out before Thursday vacating that. So I'm going to rely on the parties to let everybody, any witnesses, anybody who's on hold know that we completed the hearing today and that the November 9th date is vacated. All right, I want to thank you all for your presentations. I look forward to reviewing your statements of position. We are adjourned. Thank you.
Thank you.